Mr. Goodwin and Mr. Harris and Ms. Rawls. Mr. Goodwin, how are we proceeding today?
We can start with Brown.
Brown? That's Faye Brown?
Yes.
All right, so we're on the record in docket 2600566. That's People of the City of Lansing versus Faye Brown. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
Ms. Rawls.
Good morning, Your Honor. Assistant Public Defender Linda Rawls appearing on behalf of Faye Brown, who's standing to my right.
And ma'am, you are Faye Brown, is that correct?
Yes, sir.
All right, thank you. This time set for a plea today. Mr. Goodwin, how are we proceeding?
Your Honor, we've offered, I believe it's their intent to accept. We would dismiss the driving while license suspended and open intoxication to plead to the high BAC. That is under MCL 257-625. And then this would be under I believe 9 sub 9. And it's 2 with a maximum of 180 to 700.
All right, so it's a plea to the charge of count 1 and you're dismissing count 2, or?
Yeah, so we plead to the high BAC charge, which I believe is count 1, and then dismiss
Count 2.
Count 2 would be BWLS and open and talks.
And is that your understanding, Ms. Rawls?
Yes, it was a plea to the count 1 and dismiss count 2 and count 3.
Dismiss count 2. I don't see a count 3 on here. I just have a count 2.
It was an OWI, count 2 and count 3 was open intox.
I have count 1, the high BAC, count 2, the open intox, and I don't see a count 3, but
No, there's no count.
so I don't have a count 3. I just have a count 1 and count 2. All right, so dismiss count 2. But that's your understanding. It's a plea to count 1, dismiss count 2. Is that a correct statement, Ms. Rawls?
Yes, Your Honor.
Okay. All right, may I inquire of your client of her misdemeanor advice of rights? Ms. Rawls.
Yes, you may, Your Honor.
All right. All right. So, Ms. Brown, you have the following jury trial rights, and I'll walk you through those. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, the questioning witnesses are brought against you. You are represented today by attorney Linda Rawls, who will be present to cross-examine any witnesses or contest any charges brought against you by the people of the City of Lansing. Do you understand that, ma'am?
Yes, sir.
You have the right to have to have the court order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim to plea as a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to count 1, high BAC instead. Is it still your wish today to plead guilty to count 1 and dismiss count 2?
Yes, sir.
You can have you raise your right hand as best you can, ma'am. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right, I'm going to bring your attention back to October 4th, 2025 at the offense location of 505 Townsend Street in the City of Lansing. Were you operating a motor vehicle open to the general public on October 4th, 2025 at 505 Townsend Street in the City of Lansing?
Yes, sir.
And at that time, did you have, or did you later learn you had a blood alcohol level of over 0.17?
Yes, sir.
Anything towards a factual basis, Mr. Goodwin?
Nothing additional, Your Honor.
Ms. Rawls?
Nothing from the defense, Your Honor.
Okay, I find the factual basis to be knowing, voluntarily, and accurately made to count 1. Count 2 would be dismissed upon successful plea and sentence. I'm going to refer to probation, okay? Because they're gonna do an assessment, okay? They're gonna do an alcohol assessment to see, because it's required by statute. But we're gonna go, they may see you today, or they may set up an appointment to see you. I don't know what their schedule is. But, so we'll refer to probation. And we'll set a sentencing date. What they'll do is they'll do a report for me, and I'll see what options are available to us at sentencing.
Okay.
So we'll set for sentencing for
October 5th.
October 5th. All right, so we'll be back to see what options are available to us on October 5th at 1:30. And at that time, the count two upon successful plea and sentence will be dismissed. Anything else for the record in docket 26-00566, Mr. Goodwin?
Nothing further from the city, Your Honor.
Ms. Rawls?
Nothing further, Your Honor.
All right, Ms. Brown, go one floor down, probation's all the way to your right, and they'll either see you today or they'll set up an appointment. All right, you're all set. Thank you, ma'am.
Your Honor, there was a case yesterday where the court issued a failure to appear.
For Ms. Brown?
On Mrs. Brown, yes, Your Honor.
So let's get that file. Okay. All right, this is a state case concerning 26-01826. Ms. Rawls, we put a bench warrant with a 48-hour hold. We can clear up we can clear up the bench warrant and reset the pretrial.
Okay.
That's so we'll reset the pretrial for, let's see. So a bench warrant wasn't issued. We gave it a 48-hour hold.
Is it a pretrial or?
I think we just reset it for pretrial because we didn't have a regular pretrial.
September 14th?
All right. Yeah. September 14th at,
What's the number?
this is 26-01826, would be set on a Monday
The exact.
at 9. All right. So on file 26-01826, we'll clear up the bench warrant, or we won't issue a bench warrant because we put it with a 48-hour hold. And we've reset for September 14th at 9 o'clock. Part of Ms. Brown, you probably should tell that there's an allegation, that there's a pending allegation by the state against you when you go, just so they know, okay? And so it's not a surprise to them, because depending on what happens, that's October 5th, that's been set for sentencing, and that September 14th will come up about a couple weeks before, okay?
Would I get something in the mail?
You'll get a notice right now for that sentencing date. So you'll get a notice for the sentencing date, and you should get a notice for the pretrial on September 14th at 9 from this court officer. Okay. All right, that's all on 26-01826. We've reset the state case and we've set the city case for sentencing on October 5th. You should be all set, ma'am.
Thank you.
What time is that, October 5th?
October 5th is 1:30.
You,
So where did you want to head next, Mr. Goodwin?
you could do Walls.
Rawls,
Walls.
Terra Bray Walls.
Walls. Terra Bray Walls. All right, so we're on the record in 26000424 and the accompanying ticket of 26L2982472. That's people of the city of Lansing versus Terra Bray Walls. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the city of Lansing.
Ms. Rawls.
Good morning, Your Honor. Assistant Public Defender Linda Walls, appearing on behalf of Terra Bray Walls, who's standing to my right.
And sir, you are Terra Bray Walls, is that correct? Terra Bray, thank you. Okay, this is the time set for a final pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, the parties are still talking. I will defer to the public defender in terms of what's in hearing set, the allegation of having a permit during the time he's caught driving. I do not see that that's the evidence, but the defendant does have a new public defender, and the public defender wants to investigate those circumstances. And again, I can let the defense attorney give more information about that.
All right, Ms. Rawls.
That's an accurate statement. Your Honor, it has been alleged that the Mr. Walls has a permit. Mr. Tyler Smith was the defense attorney. This case has been assigned to me. I just want additional time to be able to investigate the Mr. Walls's claims, and so we would respectfully ask the court to set it for another final pretrial.
Well, I've set it on 2 final pretrials, but I can work some time into it so that we'll set it for jury trial, but we'll set it out sometime because we've set it for final pretrial on May 12th and it's set for final pretrial on June 23rd. So we're going to set it for jury trial, but we'll work some time so that Ms. Rawls can do her own investigation and get up to speed on the file. So set for jury trial. I would not, so not this jury trial, the next. What is the next? What is the one that you were giving me? So
you want to get some?
no, October's fine.
Okay.
So what's the date?
Yeah. October 13th at 8:15.
Okay, October 13th at 8:15. October 13th at 8:15. So set for jury trial on, well, it's set for formal hearing on the driving while license suspended. I'm sorry, it'll be set for jury trial on the driving while license suspended. The traffic signal case will be set as a part of that because I believe it's probably the same incident. Okay, and so there'll be a formal hearing aspect. The jury instructions would be due a week before that.
Yes.
So that's the same. So October 13th would be a Tuesday. So that would be October 6th, they'd be due. And that should build in some time for the parties to continue to negotiate. Anything else for the record in 26004224 or the accompanying ticket of 26L2982472, Mr. Goodwin?
Nothing else from me, Your Honor.
Ms. Rawls.
Nothing from the defense, Your Honor.
All right, Mr. Walls, we'll see you on October 13th for the jury trial, if not before. Okay, sir?
Yes.
And then who's next, Mr. Goodwin?
On all cases.
All right, Mr. Goodwin and Mr. Harris, what case are we calling next?
Why don't we do-
All right, on which case?
Cruz Borrego.
Cruz Borrego.
Last traffic signal.
All right, so we're on the record in 26000485 and the accompanying ticket of 26L2996751. That is people of the city of Lansing versus Cruz C. Borrego. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Cruz Borrego, who is standing to my right. Mr. Borrego, if you could please state your first and last name for the record.
Cruz Borrego.
All right, thank you. This time set for final pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, I believe that the parties will be asking for more time. I believe there is some additional mitigation that Mr. Harris would like to provide to me, see if it would push the needle on the driving while license suspended. I don't have the authority for that time, but with any documents, I would be able to at least consider it.
All right, Mr. Harris.
Yes, Your Honor, I spoke with Mr. Borrego last time we were in court. We were waiting for a determination on his license restoration hearing. You have had a decision on that. It was unfortunately denied. I was negotiating with Mr. Goodwin, trying to see if there was any way we could perhaps work out some kind of agreement involving a failure to display to save Mr. Borrego 1 points and 2 the additional suspension or revocation period. I did discuss with Mr. Goodwin regarding everything Mr. Borrego has been doing to try and get back on the straight and narrow, everything he did for the restoration hearing, for which he did get a substance use assessment done. I did also discuss with Mr. Goodwin the history Mr. Borrego has had of going to Narcotics Anonymous meetings, as he's indicated 4 times a week for the past 10 years, trying to get back on the straight and narrow and avoid these kind of issues from happening again. Mr. Goodwin indicated that he would need some documentary proof and some documentary evidence of that before his office would be willing to consider any kind of reduction. So we would be requesting if the court will consider one final adjournment to try and get that information to the city attorney's office.
Well, I can't give it another final pretrial, but I can work some time into the jury trial. The same as kind of the last case. So because we've set this for final pretrial on March 31st. Then we came back and I adjourned May 12th, and then I asked for another adjournment on June 23rd. So we'll set for jury trial, but we'll set it on that October date. So
October 13th at 8:15.
October 13th at 8:15 for jury trial.
What was that date, Your Honor?
October 13th at 8:15. And then we've set, and then the formal hearing that will go along with it.
Thank you, Your Honor.
At 8:15, and that'll build in some time for Mr. Borrego to continue working and provide any documentation to the city attorney. And then so October 13th, as requested, October 13th. So the jury instructions would be due October 6th. Anything else for the record in 26000485? I've set it for jury trial for October 13th and the formal hearing to go along with the jury trial on that same date, October 13th at 8:15. Anything else for the record in docket 26000485, Mr. Goodwin?
Nothing from the city.
Mr. Harris.
Nothing from your defense, Your Honor.
All right, Mr. Borrego, we'll see you on that October date. Thank you for your appearance today. Where did you want to go next, Mr. Goodwin? I have
Give me 1 second.
Berlanga on Attorney Berlanga and Attorney Shui. I also have Mr. Akanicki. So I have 3 attorneys on Zoom. But what case did you want to call next? That's really kind of an FYI, just because I don't know if you can see the same people I can see.
We can do Mr. Evans.
Mr. Hakeem Evans. All right, so we're on the record in docket 26-00227. That's People of the City of Lansing versus Hakeem Evans. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Hakeem Evans, who is standing to my right. Mr. Evans, if you could please state your first and last name for the record.
Hakeem Evans.
All right, thank you. This is the time set for a final pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, the parties have spoken and we've made an offer, and it's my indication that the defender would accept to amend the OWI 0.08 to a operating while visually impaired sentence.
That is correct, Your Honor. I have discussed with Mr. Evans. Mr. Evans, since the previous court date, Mr. Evans has completed additional mitigation, which I provided to the city attorney. At this point, I have discussed with him the operating while visibly impaired, and he has indicated that he would like to accept that offer at this time.
Okay.
I would request, after we get that plea put on the record, that we go to immediate sentencing and, well, oh, no.
I don't think we can do it because it's gonna have to be referred.
Yes, my apologies. I do believe that would be a referral.
All right, so I have Mr. Evans is charged in count 1 with a regular unlawful BAC, and he's pleading to impaired.
Yes.
To vision impaired, yes.
Okay, so operating, so it's an amended count 1. Count 1 of operating while visibly impaired. And is that your understanding, Mr. Evans?
Correct.
All right. All right. Mr. Harris may inquire of your client of his misdemeanor advice of rights.
Yes, Your Honor.
All right. You have the following jury trial rights concerning this plea, and I'm going to walk you through those. You have the right to be tried by a jury, to be presumed innocent or proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You're represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the City of Lansing. Do you understand that, sir?
I do.
Right. You have the right to have the court ordering witnesses appear in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the amended count 1 of operating while visibly impaired. Is it still your wish today to plead guilty to the operating while visibly impaired?
Correct.
All right. I'm going to be raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Now bring your attention back to August 10th of 2025 at the offense location of South Waverly Road, Coach Light Commons in the city of Lansing. Were you operating a motor vehicle open to the general public on Waverly Road and Coach Light Commons in the city of Lansing on August 10th, 2025?
Correct.
Okay. And did you later learn while you were operating that you were visibly impaired to operate the motor vehicle?
Right.
The lab results came back at a 0.11. Is that correct? That's your understanding.
Okay. Yes, correct.
Okay. All right. Anything concerning the plea to the visibly impaired, Mr. Goodwin?
Nothing additional, Your Honor.
Mr. Carries.
Nothing from the defense, Your Honor.
I find the plea to the visibly impaired to be knowing voluntarily and accurately made, And I will refer to probation. Really, it's going to be for an assessment. I don't know if assessment's been received, but that's required by statute. They're also going to do a pre-sentence report. We'll see what options are available to us at sentencing. Okay. All right. So we'll set for sentencing on October 5th at 1:30. All right, so probation is one floor down all the way to the right, and they'll either see you now or they'll set up an appointment to see you, sir, okay? All right, and then we'll come back here on October 5th at 1:30, and you'll get notice from my court officer for that sentencing. Anything else for the record in 260027, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Mr. Evans, we'll see you on October 5th at 1:30. Thank you for your appearance today.
Thank you. Probation office.
Who did you want to call next, Mr. Goodwin?
Okay, never mind.
Adams, Your Honor.
Coming down with you.
Okay.
Adams.
Sorry.
Imani. Yeah. All right, so we're on the record in docket 2600596. That is People of the City of Lansing versus Imani Adams. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the city of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Imani Adams, who is standing to my right. Ms. Adams, if you could please state your first and last name for the record.
Imani Adams.
All right, thank you, ma'am. This is the time set for a final pretrial in the matter. Mr. Goodwin, how are we proceeding?
Right, the parties are at a standstill regarding the issues. The city would be asking for a jury trial in this matter to full kind of go front in this issue. There's allegations in regards to discovery requests. I want to note that last time was the first hearing that I personally have been on this case. At the time, there was no report in our file. However, doing some additional research after the last hearing, I was able to find a couple of reports related to the incident. I did not get those reports until on about July 31st. I believe those reports were sent to the defender's office. It's been indicated that they were not sent, but it is something that we can send today. In regards to other issues, my officers will be able to testify at trial in regards to issues. And since we are still in the standstill, we will be asking for a jury trial.
All right, is that a fair statement, Mr. Harris?
I understand that is the city's request, Your Honor. At this point in time, I would actually be making a motion to have this dismissed, citing discovery issues, Your Honor. For that motion, I will note that my office sent in an appearance on this case on March 20th, 2026. In that appearance, that it clearly states in section 3, the defense is demanding any police reports concerning this case, except so much of a report as concerns continuing investigations under MCL 6.201B2. When the parties first appeared for the first pretrial on April 14th, 2026, I understand Mr. Goodwin was not in the case at that time. It was Mr. Abood. I spoke with Mr. Abood. He indicated that he had no offer to make. We had not received any kind of police report. We had not received any kind of body cam footage, and that he, on behalf of the city, was going to be requesting an adjournment to try and get a copy of that body cam and get that police report. A month later, we come back on May 26th. I spoke with Mr. Abood again. Mr. Abood advised there is currently no offer on the case, but he may have an offer at the final pretrial, depending on what he found regarding the report. He indicated that he had gotten the body cam and had turned that over, but still had no actual report from the police officer who handled the matter, and that he was still looking into getting a copy of that formal report to review for this case. and to hand over to me. Another month later, we come in on June 23rd. I speak with Mr. Goodwin, since Mr. Abood is no longer at the city attorney's office. We still have no report, no sign of the report, no indication. I make a third motion to try and get a copy of this report for discovery, because I have, given what I've seen in the body cam footage, I have some serious concerns that what is listed in that report likely may not line up with what's shown in the body cam footage. I make that report. I am able to confirm on that day that the report exists, that the report was drafted by Officer Carly Johnson, and I have the report number of the report as well, all of which I provide to Mr. Goodwin. We are now almost 2 months later, and despite all of that, having all of that information for over a month, Mr. Goodwin says his office received the report on July 31st, and that report has still not been turned over to the defense. At this point in time, Your Honor, it has been 4 months that our discovery request for this report has been outstanding, 2 months, nearly 2 months of which we have known every piece of information needed to get a copy of that report, and we still don't have a copy of that report. For all these reasons, Your Honor, at this point in time, I would be requesting the court dismiss the case for discovery issues, as, again, it's been nearly 4 months that we've been trying to get a copy of this report and nothing has been provided, Your Honor.
Mr. Goodwin, response.
Your Honor, again, in regards to the first 2 hearing dates, I was not on this case, so I cannot speak to what happened in the first 2 hearing dates. When we got to the June 23rd hearing, from what I had in the file, I had no indication that there was a report on the case. I didn't learn that there was a report on the case until the last hearing. That's why we got the report in between the last hearing and this hearing. Again, I thought after it is usually our policy that once we get additional information, we send it to the public defender's office. I believe that it was sent. I'm just now learning that it was not sent. My apologies for that, but I can send that immediately this morning.
All right, well, we started the discovery request. I have notes here that the discovery request was made in April, and now it's August, and Mr. Harry still doesn't have the requested discovery request. And I understand there's been some turnover in the city attorney's office, and you didn't come in until June 23rd, but as of July 31st, they're still missing it. And so that's my understanding is April 14th, 2026 was the discovery hearing request, and a discovery request was made. And now we're here on August 18th, and we're still, for whatever reason, we're still looking for the discovery request.
And Your Honor, I believe the only thing outstanding from what I have is that report. Everything else we have turned over.
All right.
As we have gotten.
Well, for whatever, I'm going to grant the motion to dismiss.
Thank you, Your Honor.
And this is without prejudice, Your Honor.
Yeah, it's dismissed without prejudice, which means that the people could reissue if they choose to. But this is, for our purposes, dismissed without prejudice today. I don't find any we've had a lot of transition in the city attorney's office. So, but I do, so I don't feel there was anything intentionally done. That's why it's dismissed without prejudice. But I do believe that as of April to August, we've had enough discovery requests that all the discovery requests should be met. And for whatever reason, including the losing of the assistant city attorney, Mr. Abood, that the discovery request. So I would, for the jury trial, I just put it out, ma'am. So I'd put it out till October. But I think Mr. Harris raises a good issue here, that the first request was made in April, and it's now August. So this is dismissed without prejudice for discovery purposes. So it's dismissed on the defendant. It's on a ticket, so I don't think I have to do a nollie cross because it's on a ticket.
No, it's on the ticket.
Yeah, because I think they wrote a ticket originally.
Correct. This is on the ticket, Your Honor.
Yeah.
This is not on.
So this is dismissed without prejudice. Anything else for the record in 26-00596, Mr. Goodwin,
Nothing from the city, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Ms. Adams, you should be all set. Thank you for your appearance today.
Thank you. Thank you.
All right, Mr. Goodwin, which way are we? Which case did you want to call?
Just said. Oh, is he downstairs? I'm ready.
Yeah. Your Honor, I believe I'm ready on Mr. Deshar Harris, but he should be downstairs, so we would need to be brought up.
All right, so we'll bring up Mr. Harris.
In the meantime, if the court would like to call and Faith Morehart, I don't believe she's
All right.
here.
You can call Miss Morehart, and then we do, and then did you need to meet with anybody else, or, okay,
I do not know.
all right. I have, so Mr. Bouillon is here with Mr. Shui, and Mr. Berlanga is here on Mr. Kader's case, and then Mr. Akiniki is here for Mr. Manfred. But we can go on Morehart.
Yes, I believe there is a complaining witness here on that, Your Honor, according to the city attorney, so I would understand if the court wanted to call that to release that witness.
All right. All right, so we're on the record in docket 24-01942. That's People of the City of Lansing versus Faith Morehart. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the city of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Faith Morehart, who unfortunately, Your Honor, does not seem to be here in person or via Zoom. I do not have any explanation for why there's the failure to appear. I know she has previously appeared in the past, and we previously have had good contact with her. I believe my office did try to contact her last week, but was unable to reach her. At this point in time, I would, if the court would perhaps consider a 48-hour hold or courtesy reset, I would request that. Otherwise, I would leave it up to the court's discretion.
All right.
Your Honor, I do have record of.
This was scheduled for 8:30. It is now 10 o'clock. It would appear that Ms. Goodwin, Ms. Morehart is not in the Zoom courtroom or physical courtroom. And based on the representations of counsel, it appears the defendant has failed to appear today. I do have at least 2 failed to appears. Mr. Goodwin, how did you want to proceed?
I have record of that as well, so I would ask for an immediate next one.
Okay. Based on the record indicated by Mr. Carey's that they've had some contact. She has shown up. There's no doubt she has shown up, but she's also not shown up. September, this case goes way back, but she failed to appear in September of 2024. She failed to appear in January of 2026. She failed to appear in May of 2026. So I'll issue an immediate bench warrant for Ms. Morehart's arrest. Anything else for the record in failed to appear? Anything else for the record in 24-01942? Mr. Goodwin.
Nothing from the city, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, we should be all set.
I'm going to be right back. I'm going to tell the victim.
All right. And then Ms. Wells, did you need to meet with anybody? I don't think she's here.
Oh, here she goes.
All right. Ms. Rawls, did you need to meet with anyone?
Yes, I just finished meeting with someone and then.
All right.
I'd like to do Jackie Lexie.
Okay. Let's see. Right, Mr. Goodwin, can we call Mr. Luxon? I think he has an interpreter here.
Is Mr. Wilson here?
I don't know. If
And
he's
I
not,
believe-
then we should let the interpreter go.
If
And this
he's
is
not
Mr.
here, yes, it is Mr. Rawls' case. If he's not here, I can stand in.
Right, let me identify some of these in the Zoom courtroom. On the Zoom, in the Zoom courtroom, you're listed as HRA Trading. What is your name, sir?
Good morning, Your Honor. My name is Ronnie Ayub.
And what time were you set to be here?
10 o'clock, Your Honor.
And how do you spell your last name, sir?
AUOB, as in B as in Bravo at the end.
Are you a defendant or are you a property manager for for the agency?
I am one of the owners.
You are one of the owners? Okay.
Yes, Your Honor.
Let's rename. Wolf Manfred. I think it's Wolfel Manfred.
Oh.
And how do you spell your name, sir?
My first name is RONI and last name AUOB.
All right, we've renamed you. I think Mr. Akanicki's here on that case. And on the iPhone, could you please identify yourself in the Zoom courtroom?
My name's Romero Counts.
Okay, you're here for your 10 o'clock, Mr. Counts?
Yes.
All right. I'm gonna have you. Okay, Romero Counts. All right. So I don't know if who's representing Mr. Luxon?
I believe that'd be Attorney Rawls. She hasn't been able to find her yet.
All right,
I have not been told that they appeared, but that doesn't mean.
right. Let's, Ms. Rawls, is Mr. Luxon here? Have you had any oh, he's here?
Yes.
All right, let's call that case. All right, and let me swear in the interpreter. Please state your name and spell your first name and last name for the record.
Abner St. Giles.
And-
Abner, ABNER, St. Giles, SAINT, space, GILLES.
All right. All right, let me swear you in. Do you solemnly swear from that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications will be got under the penalty of perjury? All right, you just let me know if I get going a little fast, Mr. St. Giles. All right, so we're on the record in docket 25 L2976721 and 25 L2976722. That is People of the City of Lansing versus John Luxon. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
Ms. Rawls.
Good morning, Your Honor. Assistant Public Defender Linda Rawls appearing on behalf of John Lexing.
And sir, you are John Kelly Luxon, is that correct?
Yes.
Okay. All right, thank you. This is the time set for a final pretrial in the matter. Mr. Goodwin, how are we proceeding, or would you like to defer to Ms. Rawls?
Your Honor, I would defer to Ms. Malls, but I believe that we will be setting up for jury trial. There's been an issue that's brought up regarding electric permit, but I'll let Ms. Rawls give more information about that.
All right, Ms. Rawls.
Your Honor, we would respectfully ask that the court schedule it for jury trial. I know this is the final pretrial. I just was presented with some additional evidence that I need to investigate further. So if the court would set it for a jury trial, we'd be able to investigate this matter, but also continue negotiations.
All right, so we'll set for jury trial on that October date.
Actually, I have a September date.
Yeah, let's,
You want October?
yeah, let's put in October, just to give, to work in some time, so you know. So we'll set it for October on,
You want it on the same as the other ones?
yeah, on the same date as the other ones.
I think you-
Yeah. Or one of them's gonna go, but I don't know.
October 13th.
So we'll do it October 15th at 8:15. So we'll do October 13th at 8:15. The jury trials will be, jury instructions will be a week earlier for, so it'll be, jury instructions will be due on October 6th. We've set it for jury trial, so the traffic signal will just follow the fail to display ops. And we've set this for jury trial. Let me see what they're both written on. So I don't know if is the traffic signal a misdemeanor or a, let's see. So the traffic signal is a civil infraction, and the fail to display valid license is a misdemeanor. We'll set it for October 13th at 8:15 on those files. Anything else? We will be responsible for the interpreter for that trial. And that is in Haitian Creole, is that correct?
Yes, Your Honor.
All right, and we'll order a translator for October 13th at 8:15. Anything else for the record in docket 25 L297 6721 or the accompanying ticket of 25 L297 6722? Mr. Goodwin.
Nothing further from city.
Ms. Rawls.
Nothing from the defense. Your Honor.
All right, Mr. Luxon, we'll see you on October 13th at 8:15. Thank you for your appearance today. And thank you for your assistance, the interpreter.
Thank you, sir. Thank you, Your Honor.
Just a second.
All right.
Align. Do you need to sign something?
No, we just identified.
Oh, that's fine. Let's see. There's something.
He's at 10 o'clock. We have all the Akaniki's at 9.
Well, no, I would say. I would still need to discuss with you, but.
So,
Same.
let's do it this way. This term, it's not a final.
Did you want to do Mr. Akanicki's and then that'll give some time for Mr. Harris to talk to Mr. Harris?
It's not.
We can do Harris and then we'll get to code.
Okay. So Mr. Harris, you can get next to your attorney, Mr. Harris. All right, so we're on the record in 25-02410. That's people of the state of Michigan, people of the city of Lansing versus Deshar Harris. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the city of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Shar Harris, who is standing to my right. Mr. Harris, if you could please state your first and last name for the record.
All right, thank you. This is the time set for final pretrial in the matter. Mr. Goodwin, how are we proceeding, or would you like to defer to Mr. Harris?
Your Honor, I will defer to Mr. Harris on this one.
Mr. Harris.
Yes, Your Honor. Last time we were here, there was a request to try and get some body cam footage. We have since gotten that body cam footage. I believe I got it like a week and a bit ago. It is rather voluminous with 73 items of body cam, dozens of videos. I haven't had time to fully go through it. I have discussed this case and the current offer, which would essentially be a pleading to the furnished false with an agreement to time served. Mr. Harris is currently in custody on a felony case that's up in circuit court. I believe he's got close to, if not over 150 days credit on this file since to the best of my knowledge, he's had a cash surety bond roughly the entire time he's been on this case, to my knowledge.
Yeah, he's got a 200 cash surety.
So I believe he should be getting credit for all that time, which should be somewhere in the range of 150 days now. I have discussed the offer with him. At this point, he's considering it, and we're discussing our options regarding that or potential other negotiations for both the matter of the body cam, of reviewing the body cam, the voluminous body cam discovery, and for time to consider. I would ask if the court would consider another final pretrial. I realize, however, that this is the second final pretrial, so I would also understand if the court set a jury trial date, but my request would be for another final pretrial if possible.
And Your Honor, I think the reason why there's a lot of body cam, there is a lot going on with the situation because there's other charges that he is not that's involved with the entire situation.
I think I was trying to look at the. He was failed to appear on August 29th, 2025. That would be the arraignment date. And the bond was set, and I didn't sign this, but this was somebody signed for me and requested a 1,500 10%. And I don't know if that's been changed to 200 cash surety. I was trying to figure out bond and I don't. But that's not what's holding. He's getting credit, but that's not what's holding him. Is that correct?
That is correct, Your Honor. And I believe he was arraigned on the felony case around the same time, I believe. So I believe my understanding and my guess is that the request for the 10% bond was because the attorney handling the arraignment knew he was going to be held on a higher bond on the felony case and wanted to ensure he got credit.
All right. All right. So the request is I can set it for jury trial and then we can set it out sometimes or we have a September date for jury trial. Mr. Harris, that's entirely up to you.
If the court
since he's not being held on this
charge. If the court would set a jury trial, I would simply request the court set that out a bit to give me some time
All right.
to review body cam and to discuss with my client regarding our options.
All right, so we'll set for jury trial, probably whatever date we have in
We have
October.
to go to Thursday. We already have 6 now.
Okay, October 27th at 8:15, we'll set for jury trial. So it's set for October 27th at 8:15, and then if Mr. Harris, if we see, we can also set it for plea. I mean, we can do either. I mean, it's up to you. I don't know what I don't know the nature of the case he's being held on.
I believe it's a home, alleged home invasion, Your Honor.
Right.
I was just speaking with Mr. Harris, and given how that would be set out, he did indicate to me he would like to take the plea offer if possible today.
All right. So the plea offer is plead as charged with the time served, and the time served is we're looking at the 90 days. So
yes, basically, Your Honor, if we went forward with that, I would put the factual basis on the record. And then I would be requesting that the court move to immediate sentencing, since the agreement would be time served and he's already got credit for more time than he could be sentenced to.
And the city has no problem.
All right. And is that an accurate statement, Mr. Goodwin? The offer would be plead as charged with time served.
Correct.
Okay. All right. So Mr. Harris, the offer is to plead a charge with time served concerning this case. Mr. Harris, may I inquire of Mr. Harris of his advice of misdemeanor rights? So may I inquire of Mr. Harris of his advice of misdemeanor rights?
Yes, Your Honor.
All right. Mr. Harris, you understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the city of Lansing. Do you understand that, sir? You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the false info and time served instead. Is it still your wish today to plead guilty as charged with a kilobrew of time served? Okay. And I'm going to have you raise your right hand as best you can. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay, I'll bring your attention back, sir, to August 8th of 2025 at 2200 Rio Road at or near Pleasant Grove in the city of Lansing. Were you operating a motor vehicle on the 2200 Rio Road, Pleasant Grove in the city of Lansing on August 8th, 2025? Was somebody else operating the vehicle? Okay. And at that time, were you approached by law enforcement, and did you give them some false information? So Mr.
Oh, yeah, my bad, yeah.
So you said no originally, and then you just said yes. So did you want some time to talk with Mr. Harris, or?
Yeah, I'll just take the time to talk to him.
All right. Did you want to go Mr. Akanicki's case? He's going to talk to us.
It's a code.
Okay. And the code officers here on that case?
Yes, she's Ms. Johnson.
Ms. Johnson. All right, Mr. Akanicki, you ready on the Wolfel Manfred? Is it the Manfred Wolfel rental property cases?
Yes. Yes, Your Honor. I'm ready.
All right.
And Your Honor, if we can start with 2600144201, that one may be quicker.
All right, 26. 4201 is the indication. So we're on the record in 2600144201. That is People of the City of Lansing versus Manfred Wolfel rental property. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing, and Code Officer Ms. Johnson is standing to my right.
All right. And sir, you are Robert Akanicki on this case?
Yes, Your Honor. Robert Atkins, for the defendant.
And I believe one of the owners of the property, Mr. Ayub, is here.
Yeah, I'm not sure. I haven't spoken with him, but I assume if he said
I'm
he's
sorry, Your Honor. I'm not owner of that property. I'm owner of the HRA trading property on West Michigan Avenue.
All right.
Not
so
on the Wolf.
All right. So this is the time set for a pretrial in the matter, and we reset it from a previous pretrial. Mr. Goodwin, how are we proceeding, or would you like to defer to Mr. Akanicki?
Your Honor, in this particular one, I believe this particular asset has actually been sold. So we have to move to dismiss as against this owner.
And Mr. Akanicki, do you have any objection to the dismissal for because this property has been sold?
no objection, no.
Okay. And this is on a compliance ticket. So I'll dismiss this ticket without prejudice. Property sold. All right, so anything else on 2600140201, Mr. Goodwin?
Nothing from the city, Your Honor.
Mr. Akanicki?
No, Your Honor.
All right. So that's all on that file. I just wrote it on the ROA like a regular ticket. All right, and then
from there we can just go down.
Just start at the top. All right. 416. So let's see, 26. Of course, it's the last one. All right, so we're on the record in 26001461. That is People of the City of Lansing versus Manfred Wolfel rental property. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing, and my Code Officer, Ms. Johnson is standing to my right. All
right, thank you, ma'am. And sir, you are Robert. Go ahead. Appearance for the record, Mr. Akanicki.
Good morning, Your Honor. Robert Akanicki, attorney for the defendant.
All right, this is the time set for a pretrial on a pretrial in the matter. Mr. Goodwin, how are we proceeding, or would you like to defer to Mr. Akanicki?
Your Honor, I've had a chance to communicate with Mr. Akanicki yesterday on this case, similar to the last time. The party stipulated that the property, stipulated order that the property is out of compliance. This time it would be with a $350 fine with a about 60 days for the compliance date to reset.
All right. And is that a fair statement, Mr. Akanicki?
It is kind of came to this agreement for all the pending properties here. So yes.
Okay. So this has been, and do you have an order to that effect, or am I?
There will be an order.
An order to follow?
Yes, there are drafts of it, so it should be quicker this time, but
okay,
they will be submitted.
So we'll adjourn the pretrial. There's a fine of $350. And what was the reset date or the compliance date?
About 60 days, depending on the court's timeline. if that's
All right,
okay.
so compliance in 60 days, and then we'll set it after that. We'll set the hearing date after the compliance.
Okay.
For 60 days, so. All right, so that, what's 60 days from today? So sometime after October 17th.
What do we?
Oh, we're gonna reset the pretrial.
So October 27th. So.
Yes. So we'll set the pretrial, the adjourned pretrial to October 27th at 9 o'clock. And then I'll entertain an order to follow for the $350 fine and then compliance in 60 days. So we'll have some notion of whether they complied in 60 days on that October 27th date, because the hearing date will be after the date of compliance.
And you said what time?
Wait, that was for pretrial or final?
Pretrial, yeah, at 9 o'clock. All right, so is that your understanding, Mr. Akanicki? We've set it for October 27th at 9 o'clock. I'll sign an order of fining of $350, and compliance should be made 60 days from today's date, which will be before the hearing date.
Correct.
Okay. Anything else for the record in 26001461, Mr. Goodwin?
Nothing further from the city.
All right, we're all set on that file. And then we'll go on 2600142231, which has got to be. There we go. All right, so we're on the record 2600142231. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the city of Lansing. Code Officer Ms. Johnson is standing to my right.
All right, thank you. And Mr. Akanicki, your appearance for the record.
Good morning, Your Honor. Robert Akanicki, attorney for the defendant.
All right, this is the time set for a pretrial in the matter. Mr. Goodwin, how are we proceeding, or would you like to defer to Mr. Akanicki?
Your Honor, similar to the last case, I've had a chance to speak, to communicate with Mr. Akanicki. Parties will present a stipulated order to the court that the property is out of compliance. Give 60 days to comply and a $350 fine to issue.
And is that a fair statement, Mr. Akanicki? It's a fine of $350, 60 days to comply, and we'll set the hearing date along with the other hearing in October.
That's correct, Your Honor.
All right. All right, so we'll set for additional pretrial on that hearing date of
October 27th.
at 9. All right, I'll await the order to follow. This has been a fine of $350 per the city's request and 60 days to compliance per stipulation, and we'll set the pretrial for October 27th at 9 o'clock. Anything else for the record in docket 2600142231, Mr. Goodwin?
Nothing further from the city.
Anything else, Mr. Akanicki?
No, Your Honor. Thank you.
All right. And then we have 14241. All right, so we're on the record in 2600142241. That is people of the city of Lansing versus Manfred Woelfel Rental Property. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the city of Lansing, and the code officer, Ms. Johnson, is standing to my right.
Thank you. And Mr. Akanicki, your appearance for the record.
Good morning, Your Honor. Robert Akanicki, attorney for the defendant.
All right, this is the time set for a pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, similar to the last case, I've had a chance to communicate with Mr. Akanicki. The parties will present a stipulated order that the property is out of compliance, give 60 days to comply, and a $350 fine to issue.
So reset the is that a fair statement, Mr. Akanicki?
Yes, Your Honor.
Okay, we'll reset the pretrial for October 27th at 9. I'm gonna know that date. We've set a fine for $350 to the order to follow and compliance in 60 days, which will be before the hearing date. And I'll sign an order to that effect, order to follow. Anything else for the record in docket 2600142241, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Akanicki?
No, Your Honor, thank you.
All right. And then we're on 26001331. All right, so we're on the record in docket 26001331. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing, and Code Officer Ms. Johnson is standing to my right.
Thank you. And Mr. Akanicki, your appearance for the record.
Good morning, Your Honor. Robert Akanicki, attorney for the defendant.
All right, this is the time set for a pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, the party, I've had a chance to communicate with Mr. Akanicki. Parties was present a stipulated order that the property is out of compliance, must comply in 60 days, and a $350 fine to issue.
Okay. And is that a fair statement, Mr. Akanicki?
It is, Your Honor. Thank you.
Okay, so we'll find $350 with the order to follow. It's 60 days to compliance. And we'll reset the pretrial, reset for October 27th at 9 o'clock. This is 1331, yes. All right, now I'll await the order to follow. Anything else for the record in 26001331, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Akanicki. Then we're on the record in so we're on the record in docket 26001471. That's City of Lansing versus Manfred Wolfel. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing, and Code Officer Ms. Johnson is standing to my right.
All right, thank you. And Mr. Akanicki, are you on? I don't have you on this file, but you're on all these files.
It's probably an oversight when I filed all the appearances. Depending on
all right. All right. So an appearance is to be filed on this file. Mr. Goodwin, how are we proceeding? And Mr. Akanicki, you can state your appearance for the record.
Good morning, Your Honor. Robert Akanicki, attorney for defendants.
All right. This is the time set for pretrial. Mr. Goodwin, how are we proceeding?
Your Honor, I've had a chance to speak to communicate with Mr. Akanicki. The parties will stipulate and present an order to that effect that the property is out of compliance, must comply within 60 days, and a $350 fine to issue.
So $350 fine. We're out of compliance. So we'll set. It has to be in compliance in 60 days. 60 days. And we'll reset the pretrial for October 27th. October 27th at 9 a.m. All right, so this file, I'll await the order to follow, and we'll reset it for October 27th at 9 o'clock. Will be after the date of compliance. And there's a fine of $350 to go along with this file pursuant to stipulation. Anything else for the record in 26001471, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Akanicki.
No, Your Honor, thank you.
All right. And then we're on 14181. All right, so we're on the record in docket 26001481. That is people of the City of Lansing versus Manfred Wolfel. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing, and the code officer, Ms. Johnson, is standing to my right.
Thank you. And Mr. Akanicki, your appearance for the record.
Good morning, Your Honor. Robert Akinaki, attorney for the plaintiff.
All right, this is time set for pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, I've had a chance to communicate with Mr. Akanicki. The parties will enter a stipulated order that the property is out of compliance. The compliance must be achieved in 60 days and a $350 fine to issue.
So I'll find, so the order to follow. Of this out of compliance, the stipulated out of compliance, the fine is $350. And this is set in 60, you have 60 days to get into compliance. And then we'll set the hearing date for after that 60-day compliance will be set for October 27th at 9 o'clock. And the orders to follow concerning 26001418. Anything else on the record concerning that file, Mr. Goodwin?
Nothing from the city, Your Honor.
Mr. Akanicki.
No, Your Honor.
Then we're on 9-1. So we're on the record in 26001491. That is people of the city of Lansing versus Manfred Wolfel. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing, and the code officer, Ms. Johnson, is standing to my right.
All right, thank you. And Mr. Akanicki, your appearance for the record.
Good morning, Your Honor. Robert Akinaki, attorney for the plaintiff.
All right, this is time set for a pretrial. Mr. Goodwin, how are we proceeding?
Your Honor, I've had a chance to communicate with Mr. Akanicki. The parties will enter a stipulated order as follows. First, that the property is out of compliance. Compliance must be achieved in 60 days and a $350 fine to issue.
And is that a fair statement, Mr. Akanicki?
Yes, Your Honor.
All right. So for the out of compliance, we'll find the property only $350. This is set for compliance in 60 days. For being out of compliance, we'll reset the pretrial for October 27th at 9:30. So we'll set for October 27th at 9:30 and an orders to follow. Anything else for the record? Anything else for the record in 26001491, Mr. Goodwin?
Nothing further from the city.
Mr. Akanicki.
No, Your Honor. Thank you.
All right, so we're all set on that. And then we have 2600142111. That is people of the city of Lansing versus Manfred Wolfel. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing, and the code officer, Ms. Johnson, is standing to my right.
Thank you. And Mr. Akanicki, your appearance for the record.
Good morning, Your Honor. Robert Akinaki, attorney for the defendant.
All right, this is the time set for a pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, I've had a chance to communicate with Mr. Akanicki, and the parties will enter a stipulated order as follows. The property is out of compliance. There must be compliance within 60 days and a $350 fine to issue.
All right. I will sign an order to that effect of the fine of $350 for the property being out of compliance. The owner of the property has 60 days to comply, and we'll reset the pretrial for October 27th at 9:30. Anything else for the record in 2600142111, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Akanicki.
No, Your Honor. Thank you.
All right. And then we have 26001421. And that is people of the city of Lansing versus Manfred Wolfel. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing, and the code officer, Ms. Johnson, is standing to my right.
Thank you. Your appearance for the record, Mr. Akanicki.
Good morning, Your Honor. Robert Akanicki, attorney for the plaintiff.
All right, this is time set for a pretrial in the matter. Mr. Goodwin, how is proceeding?
Your Honor, I've had a chance to communicate with Attorney Akanicki, and the parties will enter a stipulated order as follows. First, the property is out of compliance. Compliance must be achieved within 60 days and a $350 fine to issue.
And is that all a fair statement, Mr. Akanicki?
Yes, Your Honor. Thank you.
All right, I'll await the order to follow concerning the property being out of compliance. It's set for $350 fine and 60 days to reach compliance. And we'll set the additional pretrial for October 27th at 9:30. Anything else for the record in docket 2600142251, Mr. Goodwin?
Nothing from the city, Your Honor.
Mr. Akanicki.
No, Your Honor. Thank you.
All right. I don't have any further files, so those are all the files on the pretrials for the code compliance. Do you have any other files?
Not from Manfred.
Okay, all right. All right. So Mr. Akanicki, you should be all set. Ms. Johnson, thank you for your appearance today.
Thank you.
Thank you, Your Honor. Have a good day.
You too. And then Mr. Harris, are you ready on Mr. Harris?
Yes, Your Honor.
Right.
It sounds like for now we are going to be using that trial date after all.
All right.
I will be in touch with the court if we intend, depending on whether we intend to run that trial or not.
All right. So we're on the record in 25-02410. And it's my understanding based on Mr. Harris's conversations with Mr. Harris that we're going to set it for jury trial at this time. And we'll set for jury trial in October on October 27th at 8:15. I wouldn't think that Mr. Harris is being held on this file anymore.
Yes, Your Honor.
So,
He's not, yes, he's not being held on this file, he's being held on the felony file.
Right.
But he does still have the tax surety bond, so he gets credit.
All right. Does he want a PR bond on this file? Because he's over the 90 days limit on this file.
Yes, Your Honor. He
Okay.
would like a PR bond.
All right. So I'll on this file, I'll place a PR bond of $100. So on the false information, he's PR bonded on this file. I understand that there's another file out there and he's being held on that file, but he's PR bond on this file. And then we'll set it for jury trial on October 27th at 8:15. Anything else for the record? So the jury instructions would be due October 20th. Anything else for the record in 25-02410, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Mr. Harris, we'll see you on October 27th at 8:15. You should be all set, sir. And then you've been on the record. So let's give you some chance to regroup.
I have,
Unless you want to go on any cases.
there's one that I do have ready for certain, Mr. Jaden Martin.
Jaden Martin, Mr. Dobies.
Morning, Your Honor. How you doing?
Good morning. All right, let's go on that. So we're on the record in 26-01436. That is People of the City of Lansing versus Jaden Martin. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing.
Mr. Dobies.
Good morning, Your Honor. Attorney Cooper Dobies, P number 87722 on behalf of Mr. Martin, who stands to my right. Mr. Martin, could you state your first and last name for the record, please?
Jaden Martin.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Goodwin, how are we proceeding? Would you like to defer to Mr. Dobies?
Your Honor, I've had a chance to speak to opposing counsel, and we've made an offer, and it's my understanding that they intend to accept. As to count one in regards to the LWI, we're gonna agree to amend to a operating while visually impaired. And then dismiss count two in regards to operating under controlled substance.
All right, so my understanding is an amendment to count one would be operating while impaired.
Or schedule one, sorry.
And count two is to be dismissed as a part of the plea agreement?
Correct.
Okay. And Mr. Dobie, is that your understanding of the plea offer, an amended count one of OWI and a dismissal of count two after plea and sentencing on count one?
That's correct, Your Honor.
All right. All right, Mr. Dobie, may I inquire of your client, Mr. Martin, of his misdemeanor advice of rights?
You may, Your Honor.
All right, Mr. Martin, you understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented by Attorney Cooper Dobies, and he would be present to cross-examine any witnesses or contest any charge brought against you by the city of Lansing. Do you understand that, sir?
Yes, Judge.
You have the right to have the court ordering witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd be also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the operating while impaired instead. Is it still your wish today to plead guilty to the amended count one of operating while impaired?
Yes, Judge.
Okay. I'm going to have you raise your right hand as best you can. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay. I'm going to bring your attention back to January 22nd of 2026 at the offense location of I-496 and South Hosmer Street in the city of Lansing. Were you operating a motor vehicle open to the general public on I-496 West and South Hosmer Street in the city of Lansing?
Yes, Judge.
Okay. And did you later learn that you had a blood alcohol level that would make you impaired in the driving of that automobile?
Yes, Judge.
Okay. I have the PBT count was at 0.139. Anything towards a factual basis, Mr. Goodwin?
Nothing else, sir, special basis.
Anything towards a factual basis, Mr. Dobies?
Just one quick question, Mr. Martin. You have no reason to dispute the results of the testing for alcohol in your body. Is that correct?
Yes, that is correct.
Okay, Your Honor, I'm satisfied.
All right, thank you. All right, so I'll find confirm that the plea was done knowing, voluntarily, and accurately made to the amended count one of OWI. And then count two will be dismissed upon successful plea and sentence to the amended count one. So I'll refer to probation, most likely needs an assessment, some PSI, and they'll prepare a report for me. And so we'll see what options are available to us at sentencing, okay? All right, so I'm gonna refer to probation, and so probation is one floor to the fifth floor all the way to the right, and they'll either see you today or they'll set up an appointment to see you. And then we'll set sentencing for
October 5th.
Does October 5th at 1:30 work with your schedule, Mr. Dobies?
Your Honor, if I could just check my schedule
Yes.
very quickly, thank you. October 5th, 1:30, that works. Thank you.
All right. So set the sentencing for October 5th at 1:30. Anything else for the record in 26-01436, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Dobies?
Nothing for Your Honor. Thank you.
All right, I'll see you on October 5th at 1:30. We'll see what options are available. Thank you for your appearance today.
Thank you, Your Honor.
All right. Did you need to meet with anybody, Mr. Goodwin?
Maybe so. It's a little. I guess I won't be reset.
All right.
Okay.
So if you tell Mr. You tell Aline or Marcy who you need to meet with. I can put them in a room, but then we'll put you in the same room with them.
Okay.
I have Mr. Shuey. I have Attorney Shuey, Attorney Berlanga, and then Romero Counts.
I believe I spoke with, or have had communication with.
Mr. Gergwis.
Let's see.
And so I've got Romero Counts.
Berlanga, I don't need in breakout room because we already know. That's a request.
Your Honor, I'm here
Should we,
standing in on behalf of Ms. Scourges for Mr. Counts.
Okay, so you're here on, so Mr. Zarur, you're here for Mr. Counts, is that correct?
Yes, Your Honor, that's correct.
Right.
Oh,
Hassan Zarur.
that can actually go.
Okay.
If the parties are ready.
Sure. All right, so that's Romero Counts. All right, Mr. Zarur, I can call your case with Mr. Counts.
Ready, Your Honor.
All right. All right, so we're on the record in docket 1604093. Appearances for the record. Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
Mr. Zarur.
Good morning, Your Honor. Hassan Zarur, PA 3043, standing in on behalf of Attorney of Record for Mr. Romero Counts, who appears via Zoom. Mr. Counts, can you please state your name for the record?
Romero Counts.
All right, thank you. This is the time set for it's set on an order to set aside the application. Mr. Goodwin, how are we proceeding? I have a notice of letter to the prosecutor and the attorney general. I think you're the city attorney, you represent the city attorney, or?
Yeah, we're from the city. I have the motion as well in that letter.
Okay.
The city will be taking no position on this motion. We'll defer to the court.
All right, Mr. Counts, were you in possession of Mr. Zarur? Were you in possession of the letter from the attorney general indicating, and this is, I'm quoting from the letter, Counts 2017 conviction of operating a vehicle with license suspended, revoked, or denied might be ineligible for set aside because it is a traffic offense, and traffic offenses are ineligible under the law of the state of Michigan when committed by an individual with a commercial license endorsement while doing commercial operations of a vehicle. Also, a traffic offense that causes injury or death is also ineligible to set aside. Thus, the court should inquire as to whether either of these circumstances are present before allowing a set aside. Are you in possession or aware of that letter from the attorney general?
I am in possession and I'm aware of it, Your Honor. My client was not driving a commercial vehicle, did not have a commercial driver's endorsement, and there was no traffic accident for
Okay,
this conviction.
So the traffic offense that causes injury or death, it would be ineligible, is not a factor here.
It is not a factor, and Your Honor, he was not doing a commercial operation of a vehicle, and he did not have a commercial license endorsement either.
All right. I have, as of July 8th, Mr. Zarur, I have that the defendant, Mr. Romero Counts, has 7 open warrants. Are you familiar with that?
I am not familiar with that. Mr. Counts?
No, I wasn't familiar with that either, but I was familiar with the traffic warrant that I have.
I can indicate that there is a failure to appear on a traffic offense. There is a criminal bench for failure to appear in Hazel Park. There's a pickup of 50 miles on that warrant. There's a criminal bench for failure to appear out of Farmington Hills, 47th, and there is a 25 miles to pick up. There is a bench warrant for civil infraction, local ordinance for Farmington Hills, and then I've got a fail to appear for civil infraction in Farmington Hills under a local ordinance, and there's a 25-mile-an-hour pickup.
Your Honor,
Did you want to adjourn these matters to clear up those warrants, Mr. Zarur?
definitely, if we can get, a 3 to 6 month adjournment to allow Mr. Counts to deal with all these matters. It
Yeah,
sounds like there's quite a few.
I think that's probably a good idea. I have pickups in a pickup in 50-mile pickup for a fail to appear out of Saginaw. All right, so let's adjourn this hearing.
Sounds good to me, Your Honor. Would you like to pick a date now?
Yeah, we'll adjourn hearing and we'll set it about 3 months, 90 days. So adjourn hearing for 90 days to give Mr. Counts some time to clear up the fail to appears. And we'll set it for 90 days out at. Yeah, it'll be a scheduled adjournment of this one, so a scheduled motion. Okay, it'll be November 24th at 11 o'clock for the adjourned hearing. So November 24th at 11 o'clock for the adjourned hearing concerning the motion to set aside. Anything else for the record in docket 1604093, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Zarur?
No, thank you, Your Honor. I hope you have a blessed day.
You too, take care. And Mr. Counts, we'll see you on November 24th at 11 o'clock. You should be all set, sir.
One question, could I get a copy of that? Because I really never knew about those. So is there any way I could get a copy so I can see that?
I don't know if you can, like, if it was one or two, the copy runs 1, 2, 3, 4, 5 cases. I would check with our criminal division, but this comes out of Saginaw, 36th district, 52nd Clarkston district. But they all have a pickup, and if you've been outside the 25-mile pickup, then you wouldn't be aware of those. So that it's in the file, and we may be able to make you a copy of the file concerning all those pickup orders. All right, sir?
I appreciate that.
All right. So you should contact our criminal division, 54A criminal division.
All right.
Thank you, Your
Thank
Honor.
you. You're all set, Mr. Zarur. Thank you.
Take care.
hear me. And then, Mr. Berlanga, we can call your case on Mr. Kader. Appearances for the record. So you are Sir Pedro Berlanga, is that correct?
Correct, Your Honor. Pedro Berlanga, PH 6210, appearing on behalf of Mr. Kader. That's all.
All right, this is the time set for a formal hearing today on 26L301485. Mr. Goodwin, how are we proceeding?
Your Honor, the parties will ask for a reset to give defendant time to provide some mitigation circumstances.
So we'll reset the formal hearing. This will be a last reset because we set this on June 4th and then we rescheduled on July 7th. So on August 18th, this will be the last reset for formal hearing. And we'll set it, how many days out do you think?
Mr.
Berlanger, do you have?
To complete it, Your Honor, I think maybe 30 days if the court would allow.
Okay, so a month out or in that vicinity? We can go a little longer. I don't know. As long as it's on a Tuesday, I don't think it matters. So you're here this afternoon, aren't you?
Yes.
Okay.
Let's do September 15th.
Okay, we'll do September 15th at 1:30. So we'll set it for an additional formal hearing on September 15th at 1:30. Anything else for the record? 26L301485, Mr. Goodwin.
Nothing from the city, Your Honor.
Mr. Berlanger, you have the date of September 15th at 1:30.
Correct, Your Honor. That works perfect. Thank you.
All right. You should be all set. Thank you for your appearance today.
Thank you.
And then do you wanted to speak with Mr. Shuey?
Yes. I might be able to call him.
I can put if you join us, I'll put him in room 1 and then you can meet him in room 1.
Oh, I was saying I might be able to call.
Oh,
him
you
and maybe
yeah.
he can answer. Maybe that'll keep the technical go around the technical delays.
All right, Mr. Shuey, you're here on Mr. Bullion, and I think the assistant city attorney is going to call you.
Okay.
That's the plan.
Okay.
All right, so I'll take a break and you can let us know when we're ready.
Okay.
Normally we say maybe. Oh, okay, so all those.
I just needed a copy, so can you reset?
Oh, are you on that one too?
Yeah.
Okay, so hold on.
Because I think we still needed curbs.
Oh, are you with Zane?
Yeah, I'm with Zane.
Yes,
Yeah.
and that's what he wanted. And
Yep,
yes,
we still do that. Yeah,
Okay.
yep. So, I can just reset on that one.
Okay.
And then, do you have any objections if I request the court for him to appear by Zoom for the next time?
I don't. Yeah, because we're not, since we're.
Yeah. Okay, cool.
Yep.
I just basically a month or whatever the court resets it to. So.
Okay.
Getting rid of one because they. We went from 10 to 9.
Give me a second.
And then like, further with this is about cases of. Just do that. So. Becky. Come on. Not actually, it's not.
So Marcia, go ahead and start.
It's dismissed. So that one is,
All right, I'll put it in. Yeah, all these signs are happening. If not, I'll sign it. He brings right in, he's on the short one, and I suggest we do the next hour.
Michael Bullion, Jared Shui.
Just, oh, you're asking for that, asking.
Yeah. There's no face.
She's gonna take it.
Well. Statute. So we're going to set it for. I didn't know it was. There's a lot of conditions that he can. I didn't. In this particular case,
That is people of the City of Lansing versus HRA East Lansing LLC. This was set for a code compliance issue. Mr. Goodwin, your appearance for the record.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
All right, this is the time set for a code compliance case. It's previously set on July 7th. Mr. Goodwin, how are we proceeding?
Your Honor, I've had information from my code officer that there is now compliance, so we would be seeking to dismiss the case.
I think this is written. Mr. Awu.
Yes, Your Honor.
This is written on a ticket.
Correct.
All right. So I'll dismiss without prejudice. I don't know if we dismiss without prejudice per the city attorney. And Mr. Awu, you are here for HRA East Lansing, is that correct?
That's correct, Your Honor.
All right. And this has been, so at the city's request, this is dismissed without prejudice for compliance purposes. Is that correct?
Correct.
Thank you so much, Your Honor. Thank you, Mr.
All right. You should be all set. Thank you for your appearance, Mr. Awu. We're all set on that file.
Thank you. I'll have a blessed day.
You too. And then, who did you want to call next, Mr. Goodwin?
Bullion.
Mr. Bullion. Let's see. All right, so we're on the record in 26011091, 26011092, and the accompanying ticket of 26L30098001. Appearances for the record from the city of Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
Mr. Shuey.
Morning, Your Honor. Jared Shuey on behalf of Mr. Bullion, who's also on Zoom. Mr. Bullion, can you state your name for the record?
Michael Bullion.
All right, thank you. This is the time set for pretrial in the matter. Mr. Goodwin, how are we proceeding? Mr. Bullion, can you hear me all right?
Yes, sir.
All right. Mr. Goodwin, how are we proceeding?
Your Honor, the parties are continuing to negotiate. I understand this is the third formal hearing that we would ask, or third hearing that we would ask for another reset to continue negotiations.
All right, and is that a fair statement, Mr. Bowie? Chewy?
Yes, Your Honor, it is.
All right, I'm going to set this. We'll build some time into it. We'll set it for the final pretrial, but I'll adjourn it for another pretrial today so we'll set it for final pretrial. But what's the time frame we're looking at? Just so over 4 weeks.
Yes, that would be fine.
Mr. Shuey?
I would defer to Mr. Goodwin on that because he's the one that has to speak to, I believe, the supervisor is.
All right, so we'll start final pretrial for 30 days. Okay, all right. Okay, so we'll do a final pretrial on October 13th at at 8:30. It's set for final pretrial on October 13th at 8:30. And then the accompanying ticket is set for final pretrial on October 13th at 8:30. And then that should give the city enough time to consider the offer and have negotiations continue. We'll set it for a hearing on that date. Anything else for the record in 26011091, 26011092, or the accompanying ticket, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Shuey?
Nothing further, Your Honor.
All right, Mr. Bullion, we reset this for October 15th at 8:30. keep in touch with your attorney, Mr. Shui. That's all for your appearance. Thank you for your appearance today.
Your Honor, October 13th or 15th?
It's October
13th,
13th.
Tuesday, okay.
Yeah,
Right.
October 13th at 8:30. If I said October 15th,
Is that,
what's
is
that?
that in person or that's in person?
These are all traffic, so I think that can be by Zoom. So,
Okay, thank you, Your Honor.
all right, you should be all set, Mr. Shui.
All right, thank you.
Okay. All set. Okay. All right, Mr. Goodwin, who are we calling next?
Damian Martinez.
Damian Martinez. This is Mr. Dobie. All right, so we're on the record in docket 26 L300701. That is People of the City of Lansing versus Damian Martinez. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
Mr. Dobie.
Good morning, Your Honor. Attorney Cooper Dobies on behalf of Mr. Martinez this morning, who stands to my right.
And sir, you are Damian Martinez, is that correct?
Something.
All right, thank you. This is the time set for a pretrial or just set for formal hearing on this matter. And Mr. Dobies, you're covering for Mr. Zaney, is that correct?
That's correct, Your Honor.
Okay. How are we proceeding, Mr. Goodwin?
Your Honor, the parties will be asking for another reset. The opposing counsel still wishes to provide some mitigation documents, so we'll be asking for a reset to give them time to provide the mitigation.
All right, and that's your understanding, Mr. Dobie. We'll reset the formal hearing.
Yes, Your Honor, and as well, I believe if this does proceed to a formal hearing, my client would need an interpreter.
Okay.
So I would ask that that be noted in the file for the next hearing as well.
All right.
That would be a Spanish interpreter.
Okay, we'll provide the Spanish interpreter for the next hearing, and we'll set the formal hearing for what's available. All right, we'll do September 15th at 1:30. What did I say, 7:30? Surprised everybody. All right, we'll set it for September 15th at 1:30, and we'll provide the interpreter for the hearing if needed, regardless. Anything else for the record in docket? It's 26L300701 from the city, Mr. Goodwin.
Nothing further from the city.
Mr. Dobies.
No, nothing further, Your Honor. Thank you.
All right, so we've set it for September 15th at 1:30, and we'll provide the interpreter.
Thank you. All
right, thank you. All right. All right, Ms. Rawls, what case are you ready on? And Mr. Goodwin, what case are you ready on?
Mr. Bunches.
Jabari Bunches. All right, so we're on the record in 26-01543. That is People of the City of Lansing versus Jabari Punches. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from the City of Lansing.
Ms. Rawls.
Good morning, Your Honor. Assistant Public Defender Linda Rawls appearing on behalf of Jabari Funches, who's present to my right.
And sir, you are Jabari Funches?
Yes.
All right, thank you. This time set for pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, the parties would be asking for a reset for continued negotiations.
Okay. And is that a fair statement, Ms. Rawls?
Yes, it is, Your Honor.
Okay, we've set it for pretrial. I think we can adjourn this pretrial, but I don't know what the date, where the adjournment date would be. Yeah, so we've got to put it out. Okay. So.
Pre-trial?
A regular, yes, a regular pretrial. October 13th at 10. All right, we've adjourned this pretrial, set it for October 13th at 10 o'clock. Anything else for the record in 26-01543, Mr. Goodwin?
Nothing from the city, Your Honor.
Ms. Rawls.
Yes, Your Honor. Jabari has a $100 PR bond, and part of his bond condition is that he cannot leave the state without the court's permission. Jabari is a athlete, I think he's a football player at Ferris State University. They have some away games. We have the dates of those away games. They're well into December. We hope that this case ends before that, but we would like the court's permission for Jabari to be able to travel with the team for specific dates. There's a away game August 21st, another away game September 12th. There's another away game October 3rd, October 17th, November 1st.
So it's modification of bond for out-of-state travel. Any response, Mr. Goodwin, to the modification of bond for out-of-state travel for playing football purposes?
I will leave that to the court's discretion, Your Honor.
All right. So what are the dates leading? We'll go to October 13th. What are the dates that they have away games?
So it's August 21st, September 12th, October 3rd, October 17th.
So that's past the October 13th date. So I'm not going to worry about that. Okay.
Okay.
So we'll modify bond to allow out-of-state travel. For August 21st, September 12th, and October 3rd. And that is for football purposes at Ferris State. All other bond conditions apply, and also any curfew applies that is set by coaches. All right, so modify bond for out-of-state travel on August 21st, September 12th, and October 3rd, and then any curfew applies by coaches that's set by coaches. Anything else for the record? And we adjourn this pretrial to October 13th at 10 o'clock. Anything else for the record in 26-01543, Mr. Goodwin?
Nothing from the city, Your Honor.
Ms. Rawls.
Nothing from the defense. Your
All
Honor.
right, Mr. Funches, you should be all set. Thank you for your appearance today.
Thank you.
All right. Who's next, Mr. Goodwin?
Mr. Clyde.
It's who's next? I didn't get the name.
Aaron Clay Jr.
Okay, Mr. Clay. All All right, so we're on the record in 26L300435 and 26L300435. That is People of the City of Lansing versus Aaron Clay Jr. Appearances for the record, Mr. Goodwin.
Good morning, Your Honor. Keith Goodwin from City of Lansing.
Ms. Rawls.
Good morning, Assistant Public Defender Linda Rawls, appearing on behalf of Aaron Clay Jr., who's standing to my right.
And sir, you are Aaron Clay Jr., is that correct? All right, thank you. This is the time set for a pretrial and for formal hearing. Mr. Goodwin, how are we proceeding?
Your Honor, I've communicated an offer to the public defender, and I believe it's their understanding to take the offer. They would be pleading to the improper play to the Killabrew agreement, and then to dismiss the speed 1 to 5.
All right, and what's the Killabrew agreement?
It'd be no upfront jail.
And is the, do you have any objection to it going to immediate sentencing?
No objection.
Okay. And then, so it is a plea discharge to the improper plate, and then a dismissal of the speeding tickets.
Correct.
And is that your understanding, Ms. Rawls?
Yes, it is, Your Honor.
All right, Ms. Rawls, may I inquire of your client, Mr. Clay, of his advice of rights on the improper plate?
Yes, the court may.
All right. All right, you understand, sir, that you have the following jury trial rights in this case involving the improper plate. There's a Killabrew agreement. They receive no upfront jail, and then we go to immediate sentencing. If I was going to do something different from that, you'd have the opportunity to withdraw your plea. Do you understand that? Yes, sir. All right. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses are brought against you. You are represented today by attorney Linda Rawls. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the City of Lansing. You have the right to have the court order any witnesses appearing in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand the rights you have in this case, Mr. Clay? Yes, sir. If you're please accepted, you'll give up the claim that the plea was a result of any promises other than what we placed on the record, but threats it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the improper plate instead. Is it still your wish today to plead guilty to the improper plate? Yes, sir. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Yes. I'm going to bring your attention back to, if I can find the ticket. I'll bring your attention back to April 1st of 2026 at North Martin Luther King Boulevard in the city of Lansing. Were you operating a motor vehicle open to the general public on North Martin Luther King Boulevard in this Genesee Drive in the city of Lansing on April 1st, 2026? Yes. And at that time, did you have a registration and or plate violation in which was improper at that time? Yes, sir. Okay. Anything towards the factual basis, Mr. Goodwin?
Nothing from the city.
Ms. Rawls?
Nothing from the defense, Your Honor.
I find that the factual basis be knowing, voluntarily, and accurately made. And what is the code for this? Or what's the fines and costs? I guess that's what I'm more interested in. It's 90 days. 250.
I'm sorry, MCL 2. Sorry, Your Honor. MCL 257.
Okay.
255.
And what's the maximum on the fines and costs? It's 90 days and or.
It's maybe 500, but I will check that.
Okay.
About 90 days and 500.
Okay. Allocution, Ms. Rawls, concerning immediate sentencing.
Yes, Your Honor. Mr. Clay recognizes that there was a concern about his plates, and he has accepted responsibility He understands that he needs to get some proper plates on his car. We respectfully ask that the court provide as low as possible. Mr. Clay is trying to get back on his feet, and he has some expenses, and I think he is currently employed.
Yes.
He's currently employed, but there are a lot of expenses, so and he has kids and kids to take care of. So we respectfully ask the court to issue a fine that allows for accountability, but also takes in consideration his financial situation.
All right. All right, thank you. Mr. Goodwin, anything towards allocution?
The city take no position.
All right. Mr. Clay, is there anything you'd like to say to the court before the court passes sentence? All right. All right. This is for activity which occurred on April 1st, 2026. I'll set a fine of $75, cost of $75, crime victims' rights fee of $75, and I'll waive the state fee for a total of $225 to the city of Lansing. And does your client need some time to make that payment, Ms. Rawls?
Yes, he does. He needs payment arrangements.
All right. So we'll set it out for 90 days. So it'll be $225 to the city of Lansing. Let's see. November 16th. So it'll be $225 to the city of Lansing, November 16th. And then you can kind of set up your own payment plan as long as it's all paid by November 16th.
Gotcha.
It can be paid online, in person, or at the counter. So full payment will be required by November 16th. That's 90 days, and you can set up your own payment plan. Anything else for the record in docket 26L3004352? Mr. Goodwin.
Nothing from the city, Your Honor.
Right. I've dismissed without prejudice for negotiations the misdemeanor speeding ticket. Anything else, Ms. Rawls?
Nothing from the defense, Your Honor.
All right. You're all set, Mr. Clay. Thank you for your appearance today. Who did you want to call next, Mr. Goodwin?
Ms. Combs, Your Honor.
Ashley Combs. Right, so we're on the record in docket 26-01525. That is People of the State of Michigan versus Ashley Combs. Appearances for the record, Mr. Goodwin.
Good morning, or good afternoon, Your Honor. Keith Goodwin from the city of Lansing.
Ms. Rawls.
Good afternoon, Your Honor. Assistant Public Defender Linda Rawls appearing on behalf of Ashley Combs, who is standing beside me on my right.
And ma'am, you are Ashley Combs, is that correct?
Yes.
All right, thank you. This time set for a pretrial in this matter. Mr. Goodwin, how are we proceeding?
Your Honor, the city's extended an offer, I believe it would be accepted to plead to be charged to trespass under red tag, but the takeover agreement, no upfront jail. That charge is under the ordinance. I believe that is. Okay, so the ordinance under 1460.01M, and it is a 90-day, a maximum 90 days, 500.
And is that your understanding, Ms. Rawls, that there'll be a guilty plea to the charge, a Killebrew no upfront jail, and do you have any objection, or are you seeking immediate sentencing?
That is the agreement, Your Honor, and there's no objection to immediate sentencing.
All right, Mr. Goodwin, do you have any objection to immediate sentencing?
No objection.
All right. All right, Ms. Rawls may inquire of Ms. Combs of her jury trial rights concerning the 90-day misdemeanor.
Yes, you may, Your Honor.
All right, Ms. Combs, you understand that there's a Killebrew agreement between Ms. Rawls and Mr. Goodwin of no upfront jail. If I was going to do anything differently from that, you'd have the opportunity to withdraw your plea. Do you understand that, ma'am? All right. You have the following jury trial rights in this matter. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Linda Rawls. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the city of Lansing. You have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand your jury trial rights, ma'am? If your pleas accepted, it'll give the claim the plea was a result of any promises other than what we've stated on the record, or threats it was not your choice to plead guilty, but also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the trespass instead. Is it still your wish today to plead guilty to the trespass?
Yes.
You have to raise your right hand as best you can. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I'm going to bring your attention back to June 5th, 2026 at 713 North Walnut Street in the city of Lansing. Were you at 713 North Walnut Street in the city of Lansing on June 5th, 2026? And at that time, were you told to not trespass in a red tag property or to remove yourself from a red tag property? And you were you guilty? What did you do in relation to the trespass to make you guilty of trespass in red tag property?
I trespass.
Okay. And you knew the property was red tagged at the time. Is that a yes?
Yes.
All right. Anything towards the factual basis, Mr. Goodwin?
Nothing further, Your Honor.
Anything towards the factual basis, Ms. Rawls?
Nothing for the defense, Your
I
Honor.
find the factual basis to be knowing, voluntarily, and accurately made. And then allocution on behalf of Ms. Combs, Ms. Rawls.
Your Honor, Ms. Combs recognizes that she was in a location that she was not supposed to be in, and she has accepted responsibility for her actions. She is dealing with a lot of financial hardship, Your Honor. So if the court is going to impose a fine, we respectfully ask the court to issue a low fine. Mrs. Combs is currently unemployed, has no source of income. She also has fines and costs from another matter. And so she is struggling trying to pay those fines and costs. So we respectfully ask the court to provide a fine that would provide some accountability, but also take into consideration her financial situation.
All right, thank you. Anything towards allocution of Mr. Goodwin?
No position from city.
Ms. Combs, is there anything you'd like to say to the court before the court passes sentence? All right. All right, this is for activity which occurred on June 5th, 2026. I'm going to set fines and costs. A fine will be of $25. Costs will be of $25. Crime victims' rights fee will be of $75, and I'll waive the state fee for $125. And Ms. Rawls, does your client need some time to make that payment to the city of Lansing?
Yes, she does, Your Honor.
To city of Lansing. All right, so we'll provide 90 days to make payment to the city of Lansing for $125. That can be paid online, in person, or by phone. And that date is November 16th. So you can set up your own payment plan as long as it's all paid by November 16th, 2026. That'll keep you out of the show cost cycle, okay? All right, anything else for the record in 26-01525, Mr. Goodwin?
Nothing from the city, Your Honor.
Ms. Rawls?
Nothing for the defense, Your Honor.
All right, Ms. Combs, you should be all set. Thank you for your appearance today. We're on Sandra Turner. All right, so we're on the record in docket 26-01454. That is People of the City of Lansing versus Sandra Turner. Appearances for the record, Mr. Goodwin.
Good afternoon, Your Honor. Keith Goodwin from the city of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Sandra Turner, who's standing to my right. Turner, can you please state your first and last name for the record?
Sandra Turner.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Goodwin, how are we proceeding?
Your Honor, the parties will be asking for another reset for continued negotiations.
Yes, Your Honor, I did speak with Ms. Turner and Ms. Turner has been participating in outpatient treatment and substance sessions for substance use recovery. I have gotten in contact with a Miller McCutcheon, who is her counselor there. He's provided me that information, which I provided to the city attorney. I made an offer, which I believe Mr. Goodwin indicated he would need to speak with his office about, and I also plan to speak with her counselor to try and get some more information regarding her treatment over there. So at this point, we would be requesting either another pretrial or a final pretrial, Your Honor.
We'll set it for final pretrial, but did you want some time worked into it?
Yes.
Yes.
Okay, so we're, so we'll set it for final pretrial on October 27th at 8:30. So we kind of built some time into this so you can continue your rehabilitation work. But we've set it for October 27th at 8:30. Okay, ma'am? Anything else for the record in 2601454, Mr. Goodwin?
Nothing further from the city, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, you should get notice from my court officer for October 27th at 8:30 will be set for final pretrial. Then, did you want to go on? Yep, Rang.
There's Bywater and Rang that
All
I
right.
failure to, because I think if we can do Bywater.
All right, let's do Bywater. All right. All right, so we're on the record in 2601316. That is People of the State of Michigan versus Jimmy Daniel Bywater. Appearances for the record, Mr. Goodwin.
Good afternoon, Your Honor. Keith Goodwin from the city of Lansing.
Ms. Rawls.
Assistant Public Defender Linda Rawls, appearing on behalf of Jimmy Bywater.
All right, this was set for 10:30. It is now 12:16, and it would appear that the defendant has failed to appear for the pretrial. I do not see Mr. Bywater in the Zoom courtroom. I don't believe Mr. Bywater is in the physical courtroom. We'll call his name in the hallway, but based on the representations of counsel, it would appear the defendants failed to appear. Ms. Rawls, has your office had any contact with Ms. Bywater or with Jimmy Bywater?
I don't think we have, Your
All
Honor.
right. All right. So it appears the defendants failed to appear. Mr. Goodwin, how does the city want to proceed? I don't have any previous failed to appears.
That is my understanding as well, Your Honor. So I would be asking for a 48-hour hold.
All right, we'll issue a bench warrant for the failure to appear with a 48-hour hold. Anything else for the record in 2601316, Mr. Goodwin?
Nothing further from the city, Your Honor.
Ms. Rawls?
Nothing from the defense, Your Honor.
All right, we've set a bench warrant for the fail to appear with a 48-hour hold. And then we'll do Mr. Rang. Is it
I think it's
Joseph Rang Yup or Yup Rang?
I think it's Yup. Rang.
Okay, Yup Rang. All right, so we're on the record in 26L301162. That is a code compliance case, City of Lansing versus Yup Joseph Zhao Rang. Appearances for the record, Mr. Goodwin.
Good afternoon, Your Honor. Keith Goodwin from the city of Lansing. I think this is actually a hearing regarding
it's a driving
traffic. It's a
traffic
one-way street.
Yeah.
Previously it was a license case as well, but license was for cheap for first year class time.
So this is the civil infraction on the one-way street, which is all I have.
I think it's I'll look again, but I believe that's still technically a misdemeanor.
Yeah, I have that. I have checked off the box, license driving while license expired. Driving wrong way on a one-way street was a civil infraction. That's what the officer put on here.
Check again. So if it's a civil, then I guess he just defaults.
Yeah, I think it's a fail to appear. So this was set for formal hearing.
And to note to the court, I haven't had any contact with their attorney either, which is why I think this is a little strange.
Yeah, we had one on a formal hearing. Say he was gonna appear via Zoom.
No, that was the guy earlier.
That was the guy earlier? All right. All right, so this was set for 10:30. It is now 12:19. And it would appear that Mr. Reng has failed to appear. We have not heard from Mr. Ficklin or Mr. Reng, and I'm assuming you have not either. Is that correct, Mr. Goodwin?
That is correct.
All right. So that's a failed to appear. And on this civil infraction, the defendant will be defaulted. Anything else for the record in 26-301162-662, Mr. Goodwin?
Nothing further from the city.
All right, so we'll default the defendant for failure to appear on the civil infraction. I think the rest are show causes until this afternoon, and then we have you at 1:30 with the pleas, some pleas and probation violations.
Correct.
All right. And then what, ma'am, what's your name?
LaQuisha Woodard.
LaQuisha Woodard. All right. Ms. Woodard, you can come up here. There you go. All right, so we're on the record in the docket on TV 260000324. This is the time set for a show cause hearing for an outstanding balance of $135 to the city of Lansing. And ma'am, you are LaQuisha Wood, is that correct?
Yes.
It's LaQuisha Woodard.
Yes.
Okay, thank you. Do you need additional time to make that $135 to the city of Lansing?
Yes, sir.
Let's give you 90 days. We'll put it out 90 days to the city of Lansing for the $135 payment. This is from a ticket.
Sir, I could have swore I went to court. Say it was in June.
It was in March. You denied responsibility. We set for notice, and then all the notices stopped, and you defaulted on it.
I've been paying. My husband comes up here and pays every 2 weeks.
On the $135?
Yes, he paid, and then I got a thing in the mail about a ticket, and it was a total of 5 tickets. And I could have swore when I went to court, that's what the tickets, I thought that's what I was going to court for.
I have a parking violation handicap, and you were fined $135, but I don't have any payments made.
Paid on the other tickets. I don't have a total of 5, so I
haven't seen one $7.
Okay, there's been one $7 payment on this one. So take it to 135?
128.
It's 128.
Okay.
So one payment's been made on this for 128 payment. And we will set the other for 90 days out for the $128 payment. So you can continue doing what you're doing.
Okay.
I
just thought this was something else. I had no idea what this was about.
So we'll set it out for 90 days for November
16th.
It's November 16th.
Okay.
And as long as it's all paid by November 16th, you can kind of set up your own payment plan. All right. So the whatever it takes, but it all has to be paid by November 16th, and you'll stay out of that show cost cycle.
Okay.
Okay.
Gotcha.
All right, so 90 days to November 16th for $128 payment. Anything else for the record? Any questions of me, Ms. Woodard? You should be all set, ma'am. Thank you.
Now go kind of slow, because I gotta try to keep up with you, and we have a lot.
So do you want to, we'll just go and start from the top.
Okay.
So we'll go on Maria Kemp, who is balance of $270. I have a balance of $270. She was given a 30-day extension in April of 2026. She was show caused, was set on August 18th, so we show caused her for today. It appears I do not see a Maria Kemp in the Zoom courtroom, and she's not in the physical courtroom, and we'll call her name in the hallway, but it would appear that Maria Kemp has failed to appear. And we'll issue an immediate bench warrant. So that's all for the record in 22-00882. Okay. Are you ready on the next one? Johnson Robinson. So we're on the record in docket 25-01495 and the accompanying ticket of 25L2944372. This is the City of Lansing versus Johnson Robinson. This has been set for show cause hearing. I do not see Devontae Robinson Johnson in the Zoom courtroom or physical courtroom. We'll call the name in the hallway. It would appear that the defendant has failed to appear for the show cause. This was involved a $220 fine, and then the extension's been granted in April. So I'll issue an immediate bench warrant for the failed to appear. On both these files. That's file 25-01495 and 25L2944372. They came out of a plea and a plea and admission of responsibility. Looks on the civil infraction ticket, but they've both been set for show cause. It looks like you pled no contest to the other one, and that's so it's 225 on one. And then I have 220 on the other, but there'll be a bench warrant for fail to appear on both files, and that's all on the record in 25-01495. And then, are you ready on subtles?
Yep.
Okay. All right, so we're on the record in 25L2959641 and 25L2959643. That's people of the City of Lansing versus Cron Suttles. This is for an outstanding balance of $275 on the 25L2959641. And $135 on the 25L2959643. I do not see a Cron Suttles in the Zoom courtroom. There's nobody in the physical courtroom. We'll call the hallway, but there was nobody in the hallway last we looked, but we'll call that for Cron Suttles. It would appear that the defendant has failed to appear for the show cause. And an immediate bench warrant is issued. On both files. And that's all for the record in 25L2959641 and 43. I don't know if that paper was put on correctly. Then we have Miss Thomas. And I think we had a arraignment too.
No, the second one for it should have been warrant on the file.
All right, so that is. Oh.
It
Okay.
was just.
That just
she
in,
showed up.
just
then we
in
could deal with
case.
that one.
Okay.
But
I'm gonna put
alas,
DFTA for show cause. I'll write it in there. And then we're on the record in 25-03074. That is people of the state of Michigan versus Yasmin Thomas. It's time set for a show cause. I do not see Yasmin Thomas in the Zoom courtroom or physical courtroom. We'll call her name in the hallway to see if Yasmin Thomas has failed to appear. This is for an outstanding debt of $135 to the city of Lansing. And an immediate bench warrant is issued for the fail to appear. That's all for the record in 25-03074. And then we have Mr. Gates, Michael Gates. Right, so on the record in docket 25-03281. That is people of the state of Michigan, people of the city of Lansing versus Michael Yates. Here's, this is for a debt for $150 to the city of Lansing. I do not see Michael Yates in the Zoom courtroom or physical courtroom. We'll call his name in the hallway, but it appears that Michael Yates has failed to appear for the show cause hearing. And an immediate bench warrant is issued. So that's all for the record in 25-03281. Bench warrant has been issued for the defendant's fail to appear. All right, so we're on the record in 26-00823. That is people of the city of Lansing versus Keith Yesh. Appearances for the record, Mr. Goodwin.
Good afternoon, Your Honor. Keith Goodwin from the city of Lansing.
Mr. Curtis.
Your Honor, Phil Curtis, on behalf of the defendant P64563.
All right. This is the time set for a sentencing in the matter. Mr. Goodwin, are you aware of any further restitution in this matter?
Not from my comment.
All right. Mr. Curtis, you've had the opportunity to go through the pre-sentence report with your client.
Yes, Judge, I received that yesterday, the day before yesterday. Mr. Yesh and I reviewed it over the phone. Appeared to be factually accurate.
Okay, so you don't have any additions, deletions, or corrections?
None.
Okay. All right, allocution, Mr. Curtis.
Thank you, Judge. Judge, I've gotten to know Mr. Yesh a little bit over the course of this, my representation with him. You know, what I learned about Mr. Yesh is he's kind of had was dealt a difficult hand growing up. He was born to an alcoholic father that died to a traumatic alcohol-related head injury. His mother was a drug addict. He was ultimately raised by his grandmother and grandfather. Grandfather was physically abusive and ultimately also died of alcoholism. I think it took Mr. Yesh a bit of time to sort of come to terms with the seriousness of his alcohol problem when we first started working together. Fortunately, he's come around since then. He's been attending AA. He's been sober for how many days now, Mr. Yesh?
About 3 months.
2 or 3 months, Judge. And you know, we've had a number of conversations, and I've explained to him we you know, none of us have control over the circumstances in which we're born, but as we get older, we have some measure of control of how we react to those and the changes that we can make to deal with that. So we had that conversation. I was pleased to see that the probation report or the recommendation from the probation officer is geared towards getting Mr. Yesh some of the help and support that he needs. I think he really does need that level of support. So I would ask the court to adopt that. I think it's important for Mr. Yesh to continue with the Alcoholics Anonymous meeting. I think, you know, in-person meetings are important to develop, you know, some community that he can rely on for support. And hopefully he'll learn a lot through the inpatient and perhaps get connected with some additional resources he may need to continue on his journey to sobriety. So with that, Judge, I would just ask the court to adopt the recommendation, and the terms and conditions all seem generally reasonable to me.
All right, thank you, Mr. Curtis. Any comment, Mr. Goodwin?
Nothing from the city, Your Honor.
Mr. Yes, is there anything you'd like to say to the court before the court passes sentence?
I just want to say I'm glad that no one got seriously injured in my car accident, and I am sorry for the mistakes I've made. I'm doing better from now on, this day forward.
All right, this is for the plea that was taken for excessive BAC on June 9th, 2026 while driving. I'm in agreement with your attorney. I think rehabilitation is the answer here. Mr. Yesh, I know you don't feel young, but take it from an old guy, you're pretty young, okay? And you've got a long road ahead of you, okay? And it's time to figure out, you know, which path you're going to be on. It's not easy, and I don't want to make it sound like it's easier than it is. It's vigilance every day is what it's going to take. But it can be done, and it can be done with ease. I'm not concerned about Keith Yesh now because you're on probation to me. I'm concerned about Keith Yesh 3 years from now when you got to make good fundamental decisions about where you're going to be in your foundation. That's what I'm concerned about. All right. So I'm going to follow the recommendation. It is rehabilitative oriented. And I'm not going to, so I'm going to order 0 days in jail, credits given for 0 days previously served. I'm going to place you on probation. I'm not going to suspend any jail time. But your counsel knows this. Every probation violation, if there's any, is 5 days. So it's 5 days, 10 days, 15 days, 20 days. I'm not suspending any time, but I'm doing that in order that that's what we'll have to play with as we go forward. I don't see that happen. Okay, you've been clean, but you know, and I know, you know that it's hard. Okay, it's hard. But it can be done, and I've seen it done. So I'm going to put you on probation for 9 months at $30 a month. That's $270 on probation. Fines and costs, I'm going to set fines at $100 fines, $100 costs, crime victims' rights fee of $75, and state minimum cost court of $50, plus your probation, plus the oversight fee for probation. And I'll give you a round number that can be paid at the end of probation. Your probation officer is Joseph Sumter. He's the person you want to keep happy. Zoom reporting is available to you, but you should make sure you know what the ID is to get on the same page with him. So it's 220 plus 200 plus 125 for a grand total of 545. And that can be paid after your probation's done. You'll have no assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance, no use or possession of kratom. Submit to random PBTs and your analysis as directed by your probation officer. If you're clean, it shouldn't be a problem, okay? It's your time to shine, okay? If not, then you and me are gonna get to know each other a little bit. No bars or nightclubs is probably a good idea. And then if you test positive, then he's placed on other here, and I'll place it on other. Increased to intensive outpatient if test positive for substances. That may not be an issue, but that's, you know, that could be a result of it. To inpatient. If test positive. A 10, 12-step program as you're already doing right now. Obtain a sponsor as you're doing right now. I'm going to order that you attend attend the victim impact panel within 180 days with verification. And this is why, Mr. Yesh. I can sit here as a judge and I can tell people all the problems that they might have with drinking and driving. Nobody's going to listen to me, okay? They may listen to you, okay? That you may have one person who says, I'm not going to do it, and that might save somebody's life, okay? And I think that's important. That's what we're getting to here. Not purchase, possess firearms, ammunitions, or weapons of any kinds while you're on probation. And this will be abstractable to the Secretary of State for the operating while intoxicated with blood content of 0.17 or more. Any questions concerning the judgment of sentence, Mr. Goodwin?
Nothing from city, Your Honor.
Any questions concerning the judgment of sentence, Mr. Curtis?
No, I don't believe so, Your Honor. Thank you.
All right, Mr. Yesh, you should be all set. Thank you for your appearance today.
Thank you.
Judge,
Yes.
can you redo your dollar amount?
500 and I have 545. Nope. Shocker.
Try it again.
200 plus 125 plus 220.
220 or 270?
I have 220 probation. It's 270. That's my problem. Plus 125 plus 200. 595. That sound right? All right. So we have a total of 595. Okay. All right. You should be all set, sir. Thank you for your appearance today.
Judge, should he check in with the probation department?
I would,
today, or?
yeah, I would go downstairs, make sure you have the ID number in the right aspect. I don't know when Mr. Sumter is going to meet with you, but that's a person who violates you. Okay. All right.
Thank you, Judge.
Thank you. Then rip that over pretty. Yeah. All right, Mr. Goodwin, what's our next case? And
Mr. Harris, I don't know if Mr. Harris has spoken with Mr. Scott, who was on Zoom.
Probation violation.
That's an arraignment. So Mr. Nelson's here on arraignment and Mr. Scott's here on a final pretrial.
About Scott.
Did you want to talk to Mr. Scott, Mr. Harris?
Mr. Scott's on Zoom, Your Honor?
He's on Zoom.
He's on Zoom.
I would need to speak with him. I was not aware he was on Zoom.
All right, so Mr. Scott, I'm going to place you in a room and I'll place you with your public defender once he joins us, all right? I mean, you'll have to unmute, Mr. Scott.
All right.
Okay, I'm going to place you in a room. I'm going to place you in room 1, and then your public defender will be in the same room once he joins us.
Okay.
And then Mr. Nelson, we can go ahead and do Mr. Nelson, because that's a arraignment. Just a probation violation arraignment. And then is Mr. Bakari here yet?
So Your Honor, his interpreter is here.
Yes.
I just called him.
Okay.
And he said he's on his way. I don't know how far, but I
Oh.
can get here.
All right, let's do Mr. Nelson and we'll go on. I don't know how long we can hold the interpreter here.
I understand.
But we'll do Mr. Nelson first. Okay. All right, Mr. Nelson, we'll call your case. So we're on the record in docket 25015880. That is People of the State of Michigan versus Ricky Nelson. Appearances for the record, sir, you are Ricky Nelson, is that correct?
Yes, sir.
All right, thank you. This time set for a probation violation arraignment. It is alleged that you committed the following violations of your probation. I'm going to indicate to you and then some rights you have in this matter. It is alleged in violation 14, which means that there aren't 14 violations. That's just how we label it. It is alleged that you technically violated your probation by testing positive per AverHealth for alcohol on July 2nd, 2026. That is the allegation brought by your probation officer, Nathaniel Neves, and it was signed by this court on July 21st, 2026. Mr. Nelson, do you understand the nature of the allegation that's been brought against you for violating your probation? Okay.
Yes.
You understand you have certain rights in this matter, and I'm going to walk you through those rights. You have the right to a hearing. You have the right to counsel, and I would suggest that you take your right to counsel at this point. So I'm going to set this for hearing, and I'm going to provide you a phone number with the Ingham County public defender. I believe you were represented by the public defender previously on this file. Is that correct?
Yes, James Harris.
Okay. Yes. All right. So this works a little differently than the regular arraignment. The regular arraignment, Mr. Harris is here and makes his argument. You're going to have to call the Ingham County public defender, and I can provide you with a number. But we'll set this for hearing, and you should share with the public defender. They'll assign a public defender to represent you, and then you should share them this date. You should share this date that I'm going to give you. So we'll set within 14 days for formal hearing on the probation violation. It has to be 14, within 14 days. It can be in the afternoon.
It will be September 1.
All right. So it'll be September 1st at 1:30. And then let me give you the number for the Ingham County Public Defender's Office. It's 517-679-2979. And you should give him that September 1st date as part as the date of the formal hearing. Just say you're on probation to Judge Flores, okay?
Okay.
All right. So you'll be represented by counsel at that time, and then we'll go from there. We'll have the hearing. Anything else for the record in 2501580? Do you have any questions of me, Mr. Nelson?
No, sir.
All right. You should be all set. I'll see you on September 1st at 1:30. Thank you for your appearance today.
All right. Thank you.
All right. Who did you want to call next, Mr. Goodwin?
Well,
We're waiting for
James, or Mr. Harris.
All right. And Mr. Harris, is he on?
In the breakout room.
Okay. What case is he on? Is he left on?
He's with Christopher Scott. Oh.
Okay. He's with Christopher Scott. Is he on Morrow?
I believe so too. I don't know if Morrow showed up, but he's on that as well.
All right. And then, well, I'll tell you what, we've got civil stuff at 2:30, and then we've got some pre-trials. Is Mr. Harris on the 3 o'clock pre-trials?
From my information, I was told he was on the stands.
Looks like he's back.
All right.
And then we are waiting for
Mr. Bakari. I'm assuming he's done with Mr. Scott, but I don't know.
Yeah, he done. He supposed to be coming back.
All right, he's coming. He's on his way back. All right. Right.
In the hallway.
So you ready on Mr. Scott? All right. All right, so we're on the record in 2600675. That is people of the state of Michigan, people of the city of Lansing versus Christopher Scott. Appearances for the record, Mr. Goodwin.
Good afternoon, Your Honor. Keith Goodwin from the city of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Christopher Scott, who is currently joining via Zoom. Mr. Scott, if you can please state your first and last name for the record.
Yes, my name is Christopher Scott.
Right, and you can hear me all right, Mr. Scott?
Yes, I can hear you perfectly clear.
All right, thank you. This is the time set for a final pretrial. Mr. Goodwin, how are we proceeding?
Your Honor, the parties are still negotiating. I understand there have been multiple hearings in this case, but we would request one more adjournment. I will leave it to Mr. Harris to speak more about the circumstances.
All right, Mr. Harris.
Yes, Your Honor. Mr. Scott, this is an OWI .08 case. Mr. Scott has since gotten a substance use assessment done. I've gotten a copy of that. I've been able to review it. I've provided it to the city attorney's office. They've been able to review it. The city attorney's office has indicated that after reviewing their assessment, they're not willing to make an offer at this time and are looking for some additional mitigation. I've spoken with Mr. Scott regarding those options for additional mitigation. He's willing to do them. So I would simply be asking for a bit of time to get that mitigation done so that we can achieve a resolution on this case, Your Honor.
All right, we'll build in time. We're going to set for jury trial, but we're not I don't think we're in danger of setting this too soon. How's that?
Yeah.
So the jury trial would be set for
September 15th.
September 15th. Okay. So, yeah, September 15th is a month.
I mean, yeah, it seems a bit short, Your Honor. I would request that we go out of it further.
So do we have a date in October? I don't know what we have anymore.
Oh, wait.
Your Honor, from what I last remember, we were at October 27th when we were earlier.
Yeah.
8:15.
So that we'd be looking at that date.
I do believe, Your Honor, we wouldn't be expecting to run a jury trial.
We're
just trying to get that
some
extra
time for compliance
mitigation.
purposes.
Correct.
All right, so will that date October 27th work?
That would work for me.
That
Your
would
Honor.
work.
So October 27th at 8:15. All right, so we'll set it for October 27th at 8:15 to build in some time for compliance purposes. If this was to go to trial on October 27th, then I'd need jury instructions by October 20th. But you'd hear from us by then. So we've set it for October 27th at 8:15 for jury trial. Anything else for the record in 2600-675, Mr. Goodwin?
Nothing from city, Your Honor.
Mr. Harris.
Nothing to do, thanks, Your Honor.
All right, Mr. Scott, we'll see you on October 27th at 8:15, okay?
Okay.
Okay, you're all set. Thank you for your appearance today.
Yep. Thank you too.
My office made contact last week,
How about tomorrow?
but he's not here.
Okay.
He sounds sweet.
And we know Bakari's on his way, but we can only hold the interpreter so long.
Yes, regarding Mr. Morrow, I believe my office did make contact last week, Your Honor, but unfortunately he does not seem to be here today. I've tried contacting him this afternoon, but have not had any luck yet.
All right. We've had Mr. Morrow before. He's failed to appear. We'll call this. It's traffic stuff. It's all driving while license. All right, so we're on the record in 2503-681 and 2503-291. That's People of the State of Michigan versus Destiny Morrow. Appearances for the record, Mr. Goodwin.
Good afternoon, Your Honor. Keith Goodwin from the city of Lansing.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Destiny Morrow, who unfortunately does not seem to be here in person or via Zoom, Your Honor. My office did have contact with him last week regarding this court date. However, he does not seem to be here now. I did try and contact him when I noticed he had failed to appear. I have not heard back yet. I would simply request if the court would consider a 48-hour hold, but I understand there are previous failures to appear, so I would leave it up to the court's discretion.
All right, I have this was set for 1:30. It's now 2:22, and it would appear the defendants failed to appear for the plea date set. It is, I do not see Destiny Morrow in the Zoom courtroom. Destiny Morrow is not in the physical courtroom. And we'll call the hallway, but there's no need since the counsel's representations of counsel indicated that Mr. Morrow has failed to appear. I have one failed to appear by the defendant on both files. That was June 9th. And then there's a prior fail to appear for arraignment. I'm not going to count that one because that one. But there is a prior to fail to appear with a 48-hour hold previously on the file. Mr. Goodwin, how did you want to proceed?
I see. Well, formally, aside from arraignment, just one that there was a prior failure to appear, so I would ask for an immediate bench warrant.
All right. I have the fail to appear. I have a fail to appear arraignment, but I'm going to grant the fail to appear. Mr. Morrow knows his way here. And so we're having trouble getting Mr. Morrow here. It would appear. So I'm gonna issue an immediate bench warrant for the fail to appear for fail to appear on docket 25-03681 and an immediate bench warrant for failure to appear on 25-03291. Anything else for the record in either one of these files, Mr. Goodwin?
Nothing from the city, Your Honor.
Mr. Harris?
Nothing from me, thanks, Your Honor.
All right, we're all set on those two files. And then I think I can keep the interpreter here for an hour. So Mr. Bakari's got about 5 more minutes. Okay. So I got it 2:25. I'll keep you till 2:30. If it doesn't appear at 2:30, I think we have the answer. All right.
Yes, Your Honor, that's fine.
All right. I do have Suzanne Ferguson, the civil docket. And under the moniker of Ferguson, you are Suzanne Ferguson, is that correct? You can unmute, ma'am. You are Suzanne Ferguson. Ma'am, and you need to unmute. There's Mr. Nerat. All right, ma'am, you are Suzanne Ferguson, is that correct?
Yes.
All right. Let's rename her. All right, and Mr. Nerat, you're here for Miss Ferguson?
That's correct, Your Honor.
All right. And then, so we're waiting for Tyrion Maxwell, the plaintiff in the case. And so I'll give about 15 minutes of grace time and then we'll call the case.
Thank you, Your Honor.
All right, thank you. All right, and Miss Maxwell, you're here for the case involving Suzanne Ferguson, is that correct? You can unmute, ma'am. Tyrion Maxwell, you can all right. All right, this is the time set for a motion. I'll do what I do on all motions. Miss Maxwell, would you like the opportunity to speak with Mr. Nerat in a breakout room to discuss some of these motions before we get started?
We can do that for a brief time.
Mr. Narrett, would you be interested in speaking to Ms. Maxwell in a breakout room, or did you want to go forward with your motion?
Sure, Your Honor. We had a breakout room the last time we were here. I made offers to the plaintiff to get out of this and that I wouldn't be filing any claim for sanctions. And she said she wanted her day in court. So we've gone through the trouble of, I'm happy to meet with her, but I don't think it would be productive, but I'm willing to do so.
All right. You should only meet if it's going to be productive. I have two counts. I have a motion for summary disposition, and then I don't have, what's the other motion?
I filed a motion for sanctions, Your Honor.
Okay. All right. All right. So let's go forward with the motion for summary disposition. This is brought by the defendant. I have had the opportunity to read the defendant's brief in support of motion for summary disposition. Mr. Narrett, this is brought on behalf of Ms. Ferguson. So you may proceed.
Your Honor, and if the plaintiff has filed anything in response, I've not been provided with a copy of it. I don't know if the court has any sort of written response from the plaintiff.
Let's see. I don't have any formal motion for sanctions, notice of hearing, and demand for removal. Ms. Maxwell, did you file a response to this motion?
I have not filed anything, Your Honor. I am representing myself because I don't have an attorney. I can't afford one. And unfortunately, the legal services that are available don't do civil cases.
All right. So we have an answer that the motion for summary disposition was not responded to. You may proceed, Mr. Narrett.
Thank you very kindly, Your Honor. The plaintiff filed a small claims action against my client. And the nature of the claim was she claimed that debris from a property at 1026 Eureka Street here in the city of Lansing originated from that property, had landed on her vehicle during a weather event, and that she was suing my client for those damages. Based on the affidavit of my client and the other documentation I've presented to the court, one, my client does not own that property. She does not have any ownership interest either directly or indirectly in that property. It's got nothing to do with my client whatsoever. So just based on the allegations made by the plaintiff, it doesn't have any relation or connection to my client, one. Two, even if my client either did own the property directly or indirectly, I presented the court with documentary evidence showing that the city at that date and time suffered a severe weather event. And so there isn't any claim that my client was on the roof throwing debris down onto her car. It's a tornado went through the town. And if her car was damaged by flying debris, it's not anything that's attributable by way of negligence or otherwise my client. So there's no claim of how is my client at fault or responsible. Either there's no contract claim, there's no negligence claim, there's no claim that my client did anything wrong to cause this. And the fact that her vehicle unfortunately suffered damage in a weather-related event from debris that came from a building that my client has nothing to do with is no basis for her to sue my client. And I attempted to explain this to the plaintiff at our initial court appearance. I indicated that she had simply sued the wrong person or didn't have anything to do with us. And if she was willing to withdraw her claim or dismiss her claim, I would not be seeking an award of costs and attorney fees to have to defend against this case that does not have any basis in law or in fact. You have my client's affidavit. You have the other supporting documentation. My client had nothing to do with this building that the plaintiff claims the debris came off of to damage her vehicle. So I don't know why my client was sued. If her name was picked out of a hat, I don't know, but it's got nothing to do with us. We've established that. Nothing has been filed responsive to that counters anything I've submitted to the court. And with that, I think it's clear that my client is entitled to an order of dismissal with prejudice with respect to Ms. Maxwell's claims.
All right, Ms. Maxwell, response.
Yes, defendant, the address of the property is the 1022 Eureka Cole Apartments, of which the defendant is listed as the registered agent with the state of Michigan for that particular property. And on the date in question, on or about the 15th of May, the defendant and through her attorney asserts that there was a weather incident in our area. At the time, I was living in Ingham County, city of Lansing, the east side of Lansing, specifically the ABC neighborhood, which is also where the apartment building in question is also located. My property sat catty corner to the defendant's apartment building. And there was not a weather event in the place where we lived and where the defendant's building resided. Now, there was a weather event that took place in Eaton County, which again, we are not talking about Eaton County. We're in Ingham County in the city of Lansing, of which there was no tornado that touched down in that neighborhood. There was no weather event. If the weather event had been such that the winds were high enough that they caused a roof to blow off, then certainly that apartment building would not have been damaged by itself. There would have been other houses or buildings in the surrounding area that would have also been damaged. And there simply was not any damage. Again, in Ingham County, city of Lansing, east side of Lansing, the ABC neighborhood. There simply
so let me see if I understand your response. Your response is you got Ms. Ferguson's name from what?
If you look at the state of Michigan, the corporations page, what is listed is Ms. Ferguson's name and her address. I believe it's the 236 Maplewood in East Lansing. She is listed as the agent for that property. So again, as such.
So that's why she was sued in small claims.
I sued in small claims simply because of the amount that.
Well, we're not in small claims anymore. We're in district court. But that's how initially you got her name. Is that correct?
That is correct. And I initially initiated this in small claims court because of the amount of the damage. It was the
and then she got an attorney and it got taken from small claims into district court. Okay. And then correct. the indication of we're talking about May 15th as the date that you're indicating there was a tornado in Eden, but not in Ingham.
That is correct. At least not in our part of Ingham. I can't attest to elsewhere in Ingham County as a county.
I have Ingham County. We're under a tornado warning from 11:25 to 11:39.
That I cannot argue that one way or another. However,
all right.
However, again, just on the face of it, buildings
I have
are
winds around
built.
100 miles an hour and maximum path about 50 yards, 150 yards, or length was about 20 miles, about 15.5 miles.
Okay, again, that did not happen in the neighborhood that we're speaking of. If that were the case, if the weather were that severe, there would have been other buildings that were surrounding this particular property that would have been affected also. And there simply was not any other damage, neither to the houses next to, and there were houses on either side of the building, nor to my property, which is at Caddy Corner, or any of the surrounding properties on Pennsylvania Avenue and around that area. There simply was not that amount of damage. There were no downed trees. And again, my
I
car
have
was legally
damaged
parked.
number of warehouse type buildings. Tornado began in Eaton County and ended in Ingham County.
It didn't, again, Ingham County is a big county. It did not affect the area that we were in. I was there. I was sitting inside my house during this time, and I walked the property after the fact, which is when I noticed that my car was damaged. And simply there was no other building that suffered any damage other than the defendant's building or
So
the building.
the nature of the suit is, so just so I understand, the nature of the suit is Miss Ferguson, you rented from Miss Ferguson, so she must be responsible for the damage to your property.
No, I have never rented from Miss Ferguson, at least not to my knowledge. And I was not a tenant in her building. I was a tenant at a house that is adjoining her building. And
so you were
my
parked next to her building?
I'm sorry?
You were parked next to her building?
No, I was not. I was parked. I lived on Bingham Street, which is around the corner from Eureka. And I was legally parked in my driveway, not on the street, not in somebody else's driveway. I was legally parked in my driveway, the driveway that goes with the property that I was renting. And so
the
again,
property, so what is your allegation that Miss Ferguson did in order to cause damage to your vehicle?
well, the building for which she is listed as the registered agent, and again, that is all that I have been able to ascertain, that the debris that flew off of that building during the course of this so-called weather event, the tar paper came off the roof, the bricks off of the building fell down beside the building and piled up. Other bricks flew, of which one of them hit my car. There were bricks that went as far as Bingham Street.
And what caused the bricks to come down off the building?
I really don't know. My guess is when you look at the building, the state of the building and its disrepair, if you will, or the state that it was in, coupled with the wind, that is probably what caused it to happen. But again,
so your indication is the wind caused this to happen.
Well, again, there was wind. I'm not going to say there was no wind, but again, buildings are built according to a code, which means they are designed to withstand wind or any other kind of elements, with the exception if a hurricane touches, if a tornado touches. Certainly those things, those would not be argued by anyone. But my assertion is that if that was the case, the defendant's building or the alleged building would not have been the only one in isolation that suffered that kind of damage. But nobody else's roof blew off. nobody's siding blew off or was damaged. No trees came down as a result of that. No cars were turned upside down. None of the things that would have been associated with a tornado actually occurred. And so again, the assertion that I'm making is that if the defendant's building was in a proper state of repair, if the roof was put together correctly, or if it was maintained correctly, then there would not have been a reason for the roof to come off. That is not something that normally happens with a building that is in a state of good repair. And by virtue of the fact that not just a few bricks, but quite a few bricks, and like I said, the tar paper off of the roof, everything blew off into the yard of the house right next door to the building. And I did submit pictures with that with my initial filing. I don't know if those were passed on to you or not, but I did provide pictures, and they're the same pictures that I have provided to Ms. Ferguson. I have tried to reach out to her for a year now. It started the day after the event happened. A friend of mine helped me to find the information. I have spoken to Ms. Ferguson by phone. I have sent her text. I have sent her registered mail, and never once has she said to me ever that she did not own the building, that she was not at fault. She has never indicated anything. As a matter of fact, she has been pretty much non-responsive. The only thing that she has told me in the course of a year was that I could get my insurance information to her, and then she would give it to her insurance agent. Although what I was asking for was simply the name of the agency and or the policy number so that I could contact them directly. And she has avoided that for a period of a year. To this day, I still don't know who the insurance company is or if there was an insurance company. I don't know that the building was insured. I simply do not know. I know that a brick from the building came over onto my property, the property of the house that I was renting, where my car was legally parked, and it broke my windshield in the front, and it also left a tremendous dent in the roof of my car. And had it not been for the defendant's building falling apart, I would not have suffered the damage. Because again, my car was not parked on the street. It was not parked on her property. It was not parked on someone else's property. It was parked where legally I was able to park. And during this event, that is, I guess, what we're calling it, a brick from that building at the 1022, I believe, of Eureka Street, a brick from that building, when the building roof blew apart, the brick came over into my yard where my car was legally parked. And it broke my window, and it also damaged the roof of my car.
All right, Ms. Maxwell, I understand your response. Mr. Narek, response on your motion.
Yes, Your Honor, thank you. I can only go when in the affidavit and claim. The claim is that debris from property located at 1026 Eureka flew onto her car and damaged her vehicle. I can only go based on what she put into the court under oath. So,
and I may have put the wrong address in my efforts to
Ms.
get the
Maxwell, this is
information
Mr.
in.
Neritz. Ms. Maxwell, this is Mr. Neritz's turn to talk. You can continue, Mr. Neritz.
So if that's true, my client has nothing to do with that building. So it has nothing to do with her. She's not an appropriate defendant based on debris coming off that building. Now, if the plaintiff claims she made a mistake and it's a different building, that building is not there. My client does have an interest in a limited liability company that owns a building several doors away on Eureka. If that's the building that's in that issue, the proper defendant would have been the LLC, not my client personally. So there's no grounds for suing her personally under any scenario, mistaken address or not. Secondly, even if it was a claim against the limited liability company, my client and her company cannot be responsible for an act of God. If the claim was my client was on the roof throwing things down and negligently threw some stuff down on the plaintiff's car, that'd be one thing. But it's not. She claims there was no severe weather event. But then how did this debris come off of the building and cause her damage? It had to have been as a result of the severe weather event. It's called an act of God. It does not go back to my client being legally responsible by way of negligence or otherwise. Where's the duty? Where's the breach of duty? And it's not adequately asserted. So based on the affidavit and documentation I provided to the court, I think it's not a hard case, quite frankly.
All right, so I'm going to make my decision based on the evidence that I have in front of me. It appears that it appears to me, Ms. Maxwell, that the wrong address was used. At least that 1026 Eureka Street, Lansing, Michigan, is owned by the defendant. Is not a true statement, and that the wrong address was used. And then there's an act of God claim. I don't know if I ever get to the act of God claim because I don't think you sued the person responsible under your theory because you have the wrong plaintiff. That's the way I read this. But in actuality, Ms. Maxwell, if you were going to indicate that this debris came from the building, the limited liability building company, you'd have to indicate that this was not an act of God, that they did something either intentionally or neglectfully to cause this tort. And I think you need a lot of expert testimony along those lines. But I don't think you sued the right person. The address is incorrect, Ms. Maxwell. So I'm going to grant the motion for summary disposition based on the fact that Ms. Ferguson is not the owner of the property. And I'm secondary effect that the act of God has not been determined. I did see the affidavits that were attached concerning that the tornado started in Eaton County and ended in Ingham County. I'm not going to make a ruling on that because I think that's more of a factual issue. I don't think I do think that Ms. Maxwell has sued the wrong person here, and therefore I'm going to grant the motion for summary disposition. Grant the motion as a matter of law. And I'm going to deny sanctions, so there are no sanctions associated with this. But I will grant the motion for summary disposition. And Mr. Neritz, you'll follow that up with an order to that effect.
I will, sir. Thank you.
Okay. All right. So Ms. Maxwell, I've granted the motion for summary disposition. That's motion is a matter of law. So the parties, thank you for your appearance, and I'll await the order to follow.
Thank you, Ron.
Okay, thank you, Ms. Ferguson. Thank you, Ms. Maxwell.
Thank you.
Notes.